All persons having business before the Honorable Associate Judges and presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court now in session. Please come to order.
Good morning, everyone. We have 3 sets of arguments on our calendar this morning. And the first matter is 2 consolidated appeals. There is the case of Dwayne Hilton versus United States, numbers 18CO 0507 and 18CO 1109, and Rayshawn Clark versus United States, 18CO 1085 and 20CO 0479. Let me ask Mr. Williams and Ms. Walton how they plan to divide their time.
Good morning, Your Honor. Ms.
Good morning.
Walton and I have discussed, we will each be taking 8 minutes, splitting the 16 minutes that I understand are allotted to us. And I will be going first, arguing first. I'm going to reserve 2 minutes of rebuttal time.
All right, thank you very much. You may proceed.
Thank you. On behalf of Mr. Hilton, I would submit to this court that this is a case that must be reversed and a new trial granted under both Brady and Rule 33. The essence of the case is that the government did not have a particular strong case based on non-scientific evidence. What made the case for the government was the DNA evidence. If Mr. Hilton had known about the flaw in Ms. Schupman's report, he could have cross-examined her on that point. And even though it's only 1 out of 6 points, it would have shattered the aura of infallibility that DNA experts enjoy in the eyes of the jury or hold in the eyes of the jury. And it would have discredited, there is a reasonable probability, if not a likelihood, that it would have produced an acquittal or a different result, which is necessary under Brady.
Mr. Williams, can I ask you to clarify for me what the stipulation was between the parties as to the DNA report that was done post-trial? There's a footnote in one of the briefs, and perhaps it's Ms. Walton's, I cannot recall, frankly, so if you want to defer to her, that's fine. But I thought there was a footnote suggesting that the stipulation was limited to something to the effect of the report did not address certain other items or did not find error in the other items, whereas looking at the stipulation itself, I more took it that there was a stipulation that the other items, the conclusion about the other items was endorsed or accepted. What exactly was the effect of the stipulation?
It was ambiguous to me, to be quite frank, but I read the report and the report did not address those other issues. The 5 swabs that were not discredited.
Well, why do you say it's ambiguous? The particular, on page 3 of the stipulation, paragraph 8, the last of the sentences is, well, that paragraph says there were some problems identified, and then the last sentence says the remainder of the analysis was confirmed by the panel. So what's the ambiguity in whether the stipulation was, let's decide for a minute whether that's an accurate stipulation, but the stipulation.
Okay. And maybe I think I'm conflating and confusing perhaps the report itself, which does not address that, and the stipulation. I mean, there was no evidence. I mean, I saw that as ambiguous based on the contents of the report itself, and there was no documentation supporting that stipulation.
I thought that the final report said that the panel's analysis revealed no errors associated with the analysis of the 3 samples taken from the 9mm gun, specifically 2I.1, 2I.2, and 2K.2.
That is,
Am I making that up?
you're not, I'm not going to say you're making that up. I did not see that in the report, to be quite frank.
I'm searching for the page right now, but I thought it was in Mr. Hilton's supplemental record at page 56. I mean, there's what council stipulated to, and then there's what is in the report. And it just seems like the evidence is that the conclusions that Mr. Hilton was a major contributor to a mixture and that the random match probability was some, infinitesimally small number. Those aren't challenged.
No, they're not. They're not
Right,
challenged.
so then you have, 3 samples of DNA that seem solid, and, one sample of a conclusion about one sample of DNA that was never the sample that was particularly strong for the government to begin with. Right, I mean, it's the 2K.1 sample that the government elicited no testimony about on direct, and it's only elicited in cross-examination, I believe.
That's correct.
Right, that there's no major contributor and that Hilton can't be excluded from that sample. And then the new evidence is, well, actually, it's not even that he can't, that conclusion was wrong, but they still say, well, yeah, he can't be excluded. It's just that we think that there was likely 3 contributors or more, not 2 contributors. If there had only been 2 contributors, then you could say that he had to be excluded, but we don't think that that's the case. So it's a weird sort of correction. It's not kind of a slam dunk. And I get your point that it kind of undermines her analysis, but I don't see why it undermines all of the DNA in the case.
And I'm not arguing that it undermines all the DNA in the case. What it does, though, is it undermines I don't want to say credibility in the sense of truth-telling, but the plausibility, the aura of the expert. The expert, or the expertise of the expert, I should say, is what it undermines. The expert made a diagnosis, made a conclusion, prepared a report, and though she did not testify on direct about that report because the government, about that particular swab, because the government didn't bring it up on direct, on cross-examination, she could have been impeached further if, and it would have prevented her, it would have diminished the expertise that she would have, that DNA experts inevitably hold in the jury's eyes. I mean, when
I guess, sure, but how far does that get you, I guess? I mean, I guess you're assuming that the government realizes before trial that there is this error and they still put this evidence on, they still put this expert on to testify about these results. And yeah, so she gets, impeached with the fact that she didn't quite do this analysis about whether or not he could be excluded from this one sample. But, there are these 3 other samples where the science is the science and the results are the results. And you don't seem to have any argument that that is not true. And so, yeah, the jury could weigh that, but I don't see why that would actually push the balance to having the jury conclude that your client should be found not guilty?
The reason is that, you know, the expert is not giving an opinion on the ultimate issue. The expert provides these incredible numbers, you know, 1 in however many billion, trillion, quadrillion, whatever. And then on another one, then they seem so almost infallible.
But that's sort of proving my point is, right? Like there are different pieces of evidence, there are different samples. And for one sample, you know, the random match probability is given this 1 in 530 quintillion. And that is not challenged
No.
in the post-conviction proceedings or really on appeal here. And another sample, the random match probability is 1 in 12 quintillion, and that is not challenged in the post-conviction proceedings or again here. So, and a third sample is challenged in post-conviction proceedings, but it's not even a piece of evidence where the government proffered a random match probability. It was much more equivocal. And now it turns out it should have been even more equivocal. And I'm just not seeing how that really alters the evidentiary picture.
It doesn't change the findings of the other 3, but what it does do is it diminishes the credibility of the expertise in terms of the level of expertise. And if Ms. Schupman had testified or had put in her report that 2K1 was inconclusive, then your Honor would be right. But she put in that she concluded that Mr. Hilton was a contributor. By diminishing her credibility in that regard.
Well, she said there was a mixture of 2, that there was no major contributor. And, you know, I think that sort of the discussion was that there just wasn't really enough data to show who was a major contributor. And she said that he couldn't be excluded. That was her trial testimony.
Right.
Which isn't particularly strong, especially in contrast to the other evidence that she did give. Which, you know, if you were to suggest that somehow this correction undermined her conclusion about the other pieces of evidence, then we might be going somewhere. But I don't hear you saying that.
I'm not. It undermines the quality of her testing method and her.
But not as to these other pieces of evidence.
Not as to the other pieces of evidence, but if she's wrong on one thing, she could be wrong on the others. Because
Mr. Williams, can you, I'm sorry, I didn't mean to interrupt you. Go ahead.
It goes to methodology. It goes to, you know, it would present an argument that she was sloppy. Or there's plenty of trials where government asserts 4 pieces of evidence or a witness testifies to 4 facts and you impeach on one of them and discredit a witness on one. It gives rise to an argument that if he's wrong on one or she's wrong on one, she could be wrong on all the others.
You've used your time and we'll give you some time on rebuttal, but can I just ask you one other question, just a factual question? Can you remind me of where this item we've been talking about, the 9mm gun, I think, where it was found in relation to where the cell phone, Mr. Hilton's cell phone, was found?
It was found on a yard or a grassy area, I believe, near the
gun was,
site.
yes.
The gun was near the site of the crash.
And where was the cell phone found?
That was found in the vehicle. No, I'm sorry. I apologize. It was still at the scene of the robbery.
All right, those were not the same location, is that right?
No.
The yard is near where the vehicle crashed, is that right?
Yes, I believe it was about a mile away.
All right. Thank you. All right, well, we will give you a couple minutes on rebuttal. Let us hear from Ms. Walton now. Thank you, Mr. Williams.
Thank you, Your Honor.
Good morning, Ann Keith Walton on behalf of Rayshon Clark, and I will reserve 2 minutes for rebuttal as well. Mr.
All right.
Clark is serving a 31-year sentence for 2 armed robberies and an armed carjacking following a trial in which incorrect DNA testimony was introduced and his trial counsel was ineffective. And I will start with the ineffective assistance of counsel claims. First with the eyewitness identification expert. As explained in my reply brief, this court's very recent order in Jones, I believe, resolves this case, that it needs to be reversed and remanded for a new trial. And that's because the facts of Jones are very similar to the facts of Mr. Clark's case. In both cases, there were no out-of-court identifications prior to trial, and trial counsel did not believe that an eyewitness expert was necessary. Now in Jones, there was an evidentiary hearing, and the trial counsel was able to explain at the hearing that he made a strategic choice. Now this court has stated that failure to call an eyewitness identification expert cannot be considered a strategic choice. And so
Are you saying that you think Jones stands for the idea that in every case, no matter what the circumstances, it's deficient performance for a defense attorney that results in some sort of an identification for the defense attorney to fail to call, develop and introduce evidence from an eyewitness identification expert?
Your Honor, it's a case-by-case basis, but in this case, it was very similar to the Jones case. Whenever there's definitely going to be identification issues in the case, for example, in this case where nobody knew if the defendants were going to identify, the victims were going to identify the defendants, then there was a reason to believe that that could happen, and that consulting with an identification expert would be, and having the person on call during trial would be necessary. Because
thus far, your comments are focused on the deficiency part of the ineffectiveness inquiry. Do you think Jones is factually similar on the prejudice side of it, or in any event? What's your response? I mean, one aspect of the government's argument, I think the trial court's finding, is that the eyewitness identification evidence that was elicited here against your client was very weak and was effectively cross-examined without regard to an expert. And so there's just not a reasonable probability that whatever would have come from an eyewitness identification expert would have changed the outcome of the proceeding. So what's your response to that prejudice argument of your opponent?
Yes, Your Honor, the identification evidence was extremely strong in Clark. This victim, Cornell Scott, got in trial, and he stated on the second day, the first day he said he wasn't sure if he could identify anybody. The second day,
he actually said no, he couldn't. Right? I mean, he was asked by the government, and the jury saw him look around the courtroom and say, "No, I can't identify anyone."
I apologize. I don't have the transcript right in front of me, but I believe that he said, I don't think so. I believe there was.
And followed by a no.
Right. But regardless, right. On the second day, he did identify Mr. Clark. And I think a jury, it's reasonable to believe that a jury thinks, well, he's been sitting here testifying, looking at the person who could have attacked him, and he realized that he's looking at the person. And this actually happened in Jones. So in Jones, the fact that the person made the in-court ID but didn't identify him in a photo array wasn't enough to defeat the prejudice prong. So here, especially when you take into account the ineffectiveness in not calling a DNA expert, when you strip away this in-court identification, the incorrect DNA testimony, all you have is Mr. Clark with maybe with Cornell Scott's identification, but officers who had no independent recollection of actually
So-
recovering.
I mean, part of the issue though is that, the government doesn't elicit this in-court ID. That comes on from Mr. Hilton's counsel, right? And I don't believe the government says a word about the eyewitness identification by Mr. Scott in closing. So at least for the government, this continues not to be an eyewitness identification case. And it really wasn't a DNA case either. I mean, unlike in Mr. Hilton's case, where the government is relying on the DNA in closing, I don't think the government relies on the DNA. So you're talking about sort of stripping away two things that kind of weren't central pillars to the government's case ever. And what the government relied on was the fact that your client was found in the getaway car with Mr. Scott's ID and credit cards in his pocket and the gun in somewhere in close proximity. It's hard to say where since the car flipped over, but that seems to be pretty powerful evidence that your client was involved in this series of robberies.
Your Honor, first of all, with respect to the DNA evidence, the government did heavily rely on the DNA evidence in their closing. I believe they said that the DNA put Mr. Clark behind the gun. And it definitely did place Mr. Clark behind the .45 caliber pistol. The DNA evidence, actually, the testimony was that the swab that was taken from the magazine of the pistol was actually consistent with Mr. Clark's DNA, and that should have been inconsistent. So that has him really loading the gun. That was extremely devastating testimony that came in. With respect to everything
Counsel,
else,
I think in answering how, I think you're right that there was a mention of it in the initial closing, although I wouldn't necessarily go to the word heavy and then I don't remember the DNA evidence being mentioned in the government's rebuttal closing. But in figuring out the force of it, would you agree that we need to take into account how it was impeached at trial and what the DNA expert acknowledged about the limitations of the DNA evidence against Mr. Clark?
we can consider the fact that there was a cross-examination, but I think the case law is pretty clear that the cross-examination does not take the place of DNA expert testimony. This is a
Well, no,
attorney.
for sure. But I mean, it's not, this isn't so much just somebody tries to cross-examine a witness and plant some doubts through the cross, and who knows how the jury received it. Let's focus instead on kind of what the witness acknowledged on cross. So what the evidence actually was about the strength of the DNA evidence, because there wasn't just, I mean, it was pretty successful cross-examination in the sense that the defense attorney caused the witness to say a number of things about the weakness of the DNA evidence against Mr. Clark, including that it wasn't high, that the expert couldn't say it was highly probable that Mr. Clark had touched the gun, that it wasn't a high probability, that there were thousands of other people that this profile could have matched. So there was some, I mean, not to say it had zero effect, I don't mean to imply that, but I do think if we're trying to figure out what its impact was, all of that would be necessarily part of the analysis.
Yes, I believe as far as the magazine of the .45 caliber pistol on cross, the DNA expert admitted that she couldn't say with a reasonable degree of certainty that it was Clark, but she stated
Well,
on
if you have the, you may have it right in front of you. I thought she said something a little bit more than that, which was she couldn't say to a reasonable degree of scientific certainty that it was a high probability that it was Mr. Clark. Am I misread?
I believe Your Honor had stated it better than I did. I believe however, her testimony though, that was just a response to a defense attorney's question. Her testimony was that the partial DNA profile recovered from the magazine was consistent with Mr. Clark's profile. And then there was the other swab taken from the, I think, exterior, and Mr. Clark couldn't be excluded. But then,
Right. And defense counsel gets her to say that's a very common profile, and that wouldn't you agree that there's such a low probability that it literally has no weight? And defense counsel said, or the witness says that's a fair statement. She agrees that this data pretty much has no weight in the case.
But when you look at the two mistakes, I think taken together, you have testimony that it's consistent with Mr. Clark.
You were starting to suggest that there was something questionable about the evidence that Mr. Scott's a money clip was found in the pocket of your client. What were you suggesting was not quite firm or clear about that?
Well, Your Honor, at trial, it did come out that neither the officers had no independent recollection of having recovered Mr. Scott's property from Mr. Clark. It was just on the police paperwork. So there's a reasonable probability that the jury could have thought, well, maybe it was recovered from somebody else. The officers can't recall. But I also think, I also want to keep in mind that there were two separate robberies and there was a carjacking. And if Mr. Clark, if he could have very well been acquitted on one of the robberies, had this DNA evidence and the identification evidence not come in through the ineffective assistance of his counsel. For example, the identification was clear by Cornell Scott that Mr. Clark did the second robbery, where he came back and he wanted Mr. Hilton's cell phone back. And so that definitely put him behind that second robbery. However, had that not come in, the jury may very well have found that he did either neither of the robberies or the carjackings or only the first robbery.
Were you suggesting that the upshot of calling a defense expert would have been that the identification testimony would have been excluded? Because I thought you just said if it hadn't come in. But I didn't realize you were arguing that an effective attorney would have precluded this identification testimony rather than calling an expert who would have weakened it.
No, Your Honor. I will note that the trial counsel didn't file a motion to exclude an in-court identification. So he would have only been left with calling an expert to probably rebut this in-court identification. But the issue is that he didn't even consult with an expert, and he didn't have the expert.
No, I get that. Just to clarify, are you arguing as part of your ineffectiveness claim that an effective attorney would have caused this identification testimony to have been excluded?
No, because he did. No, I think that's a separate issue. If there had been an expert, I believe that the consultation with the expert would be for the purposes of calling the expert at trial.
Okay, I just thought you'd said something a minute ago. I just was trying to clarify because I thought you said something a minute ago that seemed to assume that we should be thinking about the possibility of a case where there was no ID testimony from this witness, and that's what got me a little confused. But I gather you're not trying to argue that an effective lawyer would have excluded it. You're arguing that an effective lawyer would have gotten, been prepared with an expert on identification testimony that would have undermined it more effectively than counsel did a trial.
Right.
Right.
I would argue that counsel was ineffective by not filing a motion to exclude in-court identification, but that wasn't raised below, so I can't argue it here. Here I have to focus on the expert.
Ms. Walton, thank you. Your time is up, but we will give you some extra time for rebuttal. So let us go now to hear from government's counsel. Thank you.
Good morning, Your Honors, and may it please the court. Chim Namso Kalu on behalf of Appley, the United States. Your Honors, the government is asking this court to affirm the ruling of the trial court denying both appellants' post-conviction motions, essentially because at the end of the day, there's no, the newly discovered evidence or the Brady evidence, however it's characterized, was not material to the ultimate outcome in this case. And I'll start, since Mr. Williams went first with Mr. Hilton's case. In Mr. Hilton's case, as came up during the opening argument by his counsel, there is a stipulation. There's a stipulation with respect to both cases that all of the other DNA swabs related to Mr. Hilton's DNA on the gun were confirmed by the panel. And not only is that part of the stipulation, I would also, note for the court in the supplement to Mr. Hilton's appeal before this court that the panel's final report, that is the DNA panel that reviewed the DFS, the DFS examinations, indicates that the panel was asked to look at all pending cases and others which involved prior convictions in which DFS had issued a DNA report with statistical calculations. And the report also indicated that in completing that review, the panel was asked, quote, to identify any instances in which in their opinion, the interpretation of DNA evidence or the accompanying statistical analysis was questionable, but not those which could be attributed to acceptable variation of DNA interpretation within the relevant scientific community. And I think, Your Honors, and that's the supplement 4 to Mr. Hilton's appeal before this court. I think that language is particularly important in light of the questions about the stipulation, because it does indicate that the panel would have, in order to do its work, they would have had to look at all of the pieces of evidence that were submitted to DFS or analyzed by DFS for purposes of this case. And
can I just ask you about that? So I was mistakenly reading from the stipulation earlier when I was talking to Mr. Williams. And I think we're in the same supplement. It's page 3 of the stipulation, paragraph 9. Are you saying that there's no express statement in the report that matches up with paragraph 9, but that the scope of the review that you just were reciting to me supports paragraph 9? Does that question make sense? Right, paragraph 9 makes an affirmative representation. All 3 defendants say, as part of the review, the panel of experts reviewed this case and revealed no errors associated with the analysis of 3 of the samples taken from the 9mm gun, specifically 2I1, 2I2, and 2K2. Right, that's an affirmative statement of, recognizing that there was no error, but that's not in the report itself.
What I was reading from, Your Honor, I think lends support to that statement in the stipulation, which was a stipulation between the parties and the government. I was reading not from the stipulation is.
Did the government sign on to
number
this?
6? Yes,
Sorry
it is
to interrupt. The government signed on to the stipulation because, oh yes, it did.
Yes,
Okay.
it is a joint stipulation between all the parties.
Are you
what I was reading?
Page 40? Is this from page 40 of the panel report?
Yes, Your Honor. So I was reading.
And I
Sorry.
had a question about that because it seemed a little softer than I had appreciated. It says basically, it seems to say, tell us if you think things were done that were questionable. That's the first part, and that's helpful to you, since if they're not saying anything about other things, then I guess they didn't think those things were questionable, and therefore it tends to support the idea that they were confirming or finding no errors. I get that, but the second half of that sentence seems less helpful. It says basically, don't tell us. We're not going to. The U.S. Attorney's Office at least didn't tell us to identify instances where the analysis could be attributed to acceptable variation of DNA interpretation within the relevant scientific community. Which I read, I mean, that's a little bit of not entirely clear language, but it comes across to me as, you don't have to tell us if you think something's wrong, but reasonable people could disagree about it. Reasonable scientists could disagree about it. That's not what we're looking for. What we're looking for is tell us something that is questionable in the sense of that's really not what a reasonable scientist would be saying. Am I misreading that sentence? Well, how do you interpret that last kind of the caveat where the panel was saying, don't tell us about, the U.S. Attorney's Office did not instruct us to identify instances that could be attributed to an acceptable variation of DNA interpretation within the relevant scientific community.
So I interpret that, Your Honor, as it is true that the panel report elsewhere makes reference to the fact that there are different interpretations that could be made about different evidence that would be perhaps different experts could disagree, but it would not be the case that either of the experts was necessarily incorrect. And so my point in quoting that language to the court is that in order for the panel to have done its work, it necessarily would have had to review all of the evidence that was analyzed by the DFS analysts in this case.
That seems like a fair point, but just let me ask my question in this concrete way. Given what is said here in this sentence that you were quoting, if the panel had looked at the results in this case other than the ones that it communicated back as saying there were problems, and it said to itself, on this other swab, that's really not what I would conclude as an expert, but other experts could reasonably conclude it. And so I don't feel like that's something I need to pass along in this report, because that's not what we were asked to do. Would that have been a reasonable way for the panel to have, is that a reasonable way to understand this language, that the panel didn't feel it incumbent to identify every point it disagreed on, but rather only those points where it's like reasonable people couldn't have thought this? So that's my first question. Is that a reasonable way to read that sentence, or do you have some different way of reading it?
I think that is certainly one way to read the sentence, Your Honor, but I would also, I started out by this line of discussion by talking about the stipulation and what the stipulation says, which is what the parties discussed. And this, I believe, counsel for Mr. Clark in the Superior Court stated on the record on April 25th that the parties got together and wrote this stipulation in lieu of presenting live testimony, which suggests this was not just somebody taking anybody. I think it's reasonable to infer based on that statement, based on the fact that the stipulation exists, that there were discussions about what it should say, and that there was a basis to believe the panel had confirmed the other the conclusions for the other evidence.
Can I ask you whether you may be making one of 2 points? I'm just trying to figure out whether, or you could be making both of them, I guess. One aspect of your point is, well, whatever the report said, the stipulation was what the stipulation said, and for current purposes, we should be analyzing it based on the stipulation and not trying to figure out whether that was prudent or not prudent. I get that line of thought if that's one of your points. Another possible point, which it seemed like you were hinting at, I just want to make sure that you're suggesting that, is, for all we know, the stipulation is a result of further information that's not reflected in this report about what the experts did or didn't do in this particular case, or the panel thought or didn't think in this case. So we don't really know what all may have been the basis for the stipulation beyond the report. I thought you might have been hinting that, but I just wasn't sure whether that's an aspect of what you're suggesting also.
I can't speak to that second point, Your Honor, because there's not, I don't have a record, and certainly it's not in the record what the parties discussed. I was just making the point that in submitting the stipulation in lieu of presenting live testimony, for example, from a post-conviction expert, this is what the parties gave to the court. And this stipulation that the parties gave to the court says that the panel confirmed the swabs that were not raised as problems in the DFS disclosure that was made in 2015. And so going back again to the facts of Mr. Hilton's case, what that leaves the court with is a stipulation that, I know we've been talking about 4 pieces of evidence. I think the record actually reflects that there were 6, that there were wet and dry swabs of the magazine and the exterior of the .45 caliber handgun. So the way that I read the record, and this is set forth at page 7 of our brief, there are actually 6 pieces of evidence of DNA evidence tying Mr. Hilton to that .45 caliber gun. And 5 of those are not challenged. And 5 of those, according to the stipulation, were confirmed by the panel. In addition, there was an eyewitness identification by the victim, Tyrone Scott, of Mr. Hilton during the trial. And in addition to that, his cell phone, Mr. Hilton's cell phone, was found near where Mr. Tyrone Scott was robbed. And we know it was his phone because the detective saw an incoming number. The number that was calling the phone turned out to be Mr. Hilton's sister. And additionally, there were photos of Mr. Hilton and his child on that phone. And that's all in the trial testimony. And so given all of that, with respect to Mr. Hilton's case, the government does not believe that there is a reasonable probability that there would have been a different outcome, even if the error with respect to the number of contributors for the single swab at issue in Mr. Hilton's case. We don't believe that would have changed the outcome of the trial.
Ms. Kalu, I'm sorry if I just missed it, but did you say where the 9mm gun was found?
That 9mm gun was found in a yard on 4th and Ingram Street, where this SUV had flipped over. So not where the robberies took place, but where the SUV that the police had chased flipped over, and from which 2 of the assailants fled.
So both guns are found near the SUV.
Yes, that's correct.
Okay, thank you.
Did you want to go to Mr. Clark?
Yes, Your Honor. So with Mr. Clark's case, I'll start, as counsel did, just noting the Jones case. I don't think that the Jones case is quite on all fours with this case, with Mr. Clark's case, for the following reasons. Although there was an ID aspect to this case that was unexpected, that's not the only evidence that was in the case. The evidence that was in Mr. Clark's case was, it far exceeded simple eyewitness testimony. In particular, he was found in the back of an SUV that police had chased upon the conclusion of the second robbery. And I think it's one thing that's important to note about that second robbery is that the police had been called. And the first responding officer, Officer Garcia, as he was pulling up to the house where the complainant was, saw somebody running away from the complainant and getting into the back seat of the SUV. The complainant, Mr. Scott, then testified that that person had put a gun to his face and had taken his cell phone. That's the same person, even though Officer Garcia did not make an eyewitness identification of the individual he saw running across.
Wasn't there a difference between the clothing, right? Didn't Mr. Scott recall that he had been held up by someone in black clothing and the officer saw someone in a white t-shirt and jeans or something running into the car? So it sort of doesn't match up.
There was a discrepancy, yes, Your Honor, which I believe counsel brought out on cross-examination. But I would note for the court that there was also two things. First, that Cornell Scott, the victim who identified Mr. Clark, said that he couldn't quite remember what the assailant was wearing, that it was dark. He thought it might be dark clothing. And I read his testimony as equivocal on that point. But regardless, in addition to finding Mr. Clark in the overturned SUV with the proceeds of the robbery and the .45 caliber handgun, if I remember correctly, there was also a dark colored sweatshirt there. And so there, circumstantially, those two identifications, the clothing identifications, I think there was evidence in the record that a jury could have reconciled to the extent that that was something that they had an issue with.
You remind me of a question, I just don't recall right now what the record suggests about how much time passed between the end of the first robbery and the perpetrators pull off in the car and then their return to try to recover what they thought was a phone they'd left behind. Is the record, how big is that gap?
Mr. Cornell Scott said he thought it was around 15 minutes between the two, and that's at pages 133 to 135 of the January 30th transcript. Nobody else, to my recollection of the record, provided a window. But in that time frame, he was robbed the first time and carjacked. The other Mr. Scott was robbed, and then the car left.
Is that 15 minutes between? My question was had very specific end points and beginning points, and I'm not sure whether Mr. Clark's testimony had Mr. Smith's testimony had the same endpoint and beginning point. So my question was like end of first robbery at the time that folks flee, and point of return. You're saying that's what that's what Mr. Cornell Smith said was 15 minutes.
I read that to be yes, from the end of the first incident to the return of the that it was around 15 minutes.
Right, I guess because to the extent that Mr. Clark's theory of the defense was in part possible innocent presence, I guess the longer that gap is, the greater the possibility that folks have committed the robbery, they drive away, they're driving around for a while, maybe they end up picking up Mr. Clark, then somebody realizes, oh, where's my gun, my phone, and they go back, and then Mr. Clark is kind of caught up in something he was involved in. That's, I guess, an aspect of the theory of the defense. Is that right? And I was just trying to figure out what the time frame was for that.
That is one of the points that was argued by Mr. Clark's trial counsel. But of course, the police, in finding Mr. Clark in this overturned SUV, found him with proceeds from the first robbery in his pockets. All that was taken during the second robbery was Mr. Cornell Scott's cell phone, which was also in the car. But proceeds from the first robbery were found in Mr. Clark's pockets.
Ms. Walton says that that's indicated in a police report, but that no officer who testified recalled that. I think that's what she said. Do you have more to say on that point?
My recollection of the record, and I believe it was Officers Caceres and Rebenak who testified to this, that they were involved in removing Mr. Clark from the SUV, and they could not remember which one of them took the items out of his pockets, but they did believe that they did testify rather, that one of them took the items out of his pocket. So I think it was more than just a reliance on paperwork. It was, not the best memory, but that was what they recalled. And indeed, that's the trial court found that those items were taken, that the police took those items out of Mr. Clark's pockets.
All right.
So you just said that the trial court found that? In what context?
In
Was
the
there a
context
chain
of
of custody argument?
Oh, no, I'm sorry, Your Honor, not during the trial itself. I'm referring to the trial court's findings on the post-conviction motions. In reviewing the evidence in Mr. Clark's case, in light of the DNA disclosures, the court concluded that there was overwhelming evidence, aside from the DNA, tying Mr. Clark to all of the offenses in this case, or rather to the robbery of Cornell Scott and to the carjacking. And in going through that evidence, that was one of the findings that the trial court made.
Ms. Kalu, you're out of time. Unless there's another question or you have some burning point you need to make in 30 seconds. Thank you very much.
Thank you, Your Honor.
All right, thanks. Mr. Williams, we'll give you 2 minutes on rebuttal if you need it.
Thank you very much. Real quick, regarding my confusion with between the stipulation and the report, I believe that's been addressed, and I apologize because I was searching through the report to see if there was language that matched the stipulation. What had me worried for a while, but what I would conclude and try to impress this court upon is the fact that we don't know what testing was done. We know that the 2K1 was tested. We don't know if the Budell panel looked at the other samples.
But my problem with that, Mr. Williams, is that at least your predecessor, your client's lawyer in the post-conviction proceedings, walked into the Rule 33 hearing and said, here, Your Honor, we want to make this easy for you. Here's our stipulated set of facts. Now rule on this. And they didn't ask for a hearing about, what was tested or when, or, and the stipulation, as we've discussed, was pretty strong in its language in saying these other 3 samples, there's no problem with them.
Well, it doesn't. I would take issue, Your Honor, respectfully. It says that they reviewed the case. The panel reviewed the case. We're not disputing it reviewed the case.
No, it says the panel's analysis revealed no errors. And then they don't talk about it anymore. I think the clear implication to a trial judge is these facts are not, in dispute and they're off the table. I don't need to worry about these other 3 samples.
If the word case, if the word swabs were there instead of the word case, I would agree with Your Honor, but it's not.
No,
And that's,
this panel's analysis, quote, revealed no errors associated with the analysis of the 3 samples taken from the 9mm gun, specifically to I.1, to I.2, and to K.2.
yes, again, but we don't know if they actually analyzed the swabs. We know that they don't.
Counsel didn't ask the court to have a hearing on that, is my point.
There is no dispute as to that. But what I submit that the court was presented with was a record that we don't know if the Bedole panel actually examined those 3 swabs or did.
The swabs, I mean, I don't think anybody, it doesn't seem like anybody contemplated that someone was going to go physically find the swabs and then start doing further science with electrophoresis or however they're doing it these days. I think everybody thought that the concern to be looked at was about mixed samples and how to interpret results that had already been generated in a lab. And it was more about the statistics and interpretation of the scientific results. So are you saying, I mean, if to the extent you're saying it's unclear whether anybody went back and actually physically looked at the labs and reran test results, I think you're right. In fact, it's pretty clear they didn't do that. Is your point that you think it's unclear that anybody checked with respect to these swabs, these items, the analysis and the statistical analysis and conclusions was reached? Because if that's your point, that seems a little harder to square with the report and the stipulation.
It is hard to square with the stipulation, but what it does go to is it talks about the systemic errors, and there's no getting away from the fact that there were systemic errors. And if a jury had been told that there were systemic errors that led to the production or led to the conclusion regarding 2K1, and that we don't know what was done with the others, that would have been compelling evidence that would have diminished the expertise, the aura of infallibility, as I've said, about the expert, the DNA expert. And that would have left the jury with Mr. Tayon Scott's identification of Mr. Hilton in court after having, and he was effectively impeached, very effectively impeached by the fact that he had previously made a wrong identification, an erroneous identification, or identified someone other than Mr. Hilton in a photo array shortly after, or a few days after the robberies.
Mr. Williams, thank you. I think we have your argument. You can finish your sentence.
Okay. That's all I have.
All right. You were about to say something and I cut you off, for which I apologize.
It's fine.
All right. Thank you. Ms. Walton, 2 minutes to you as well.
Thank you. Yes, with respect to the DNA issues, I think for Mr. Clark, the incorrect testimony was especially devastating. And this merits a new trial where he should have a hearing, he should have an evidentiary hearing to question his trial counsel about what exactly did trial counsel retain an expert witness? How much did he consult with the expert witness? What records did he give the expert witness? Did he consider calling the expert? Beyond the Innocence Protection Act hearing, what was the level of consultation with the expert witness, and would he have, did the expert go and watch the DFS testing, for example? And if not, why? Because with the evidence we have before us here, and there's a very reasonable probability that if a defense expert had evaluated this case prior to trial, he or she may have uncovered the issues with DFS and the government's records. And then presumably, if that happened, the DNA expert possibly wouldn't have even testified at this trial. And then going back to the eyewitness issue, the government made some points about Jones. I want to focus on, there's several different crimes here. There's the first robbery, there's the second robbery, and then there's the carjacking. I don't think anyone connected Mr. Clark directly with me. He didn't do the carjacking. The carjacker got away. But there was a definite question based on the identifications of whether he did the first or the second robbery or one of them. And that DNA evidence putting him behind the gun and the identification evidence at trial did definitely connect him to the second robbery. And as Judge McLeese made the great point, that was the longer, the 15 minutes that went by, it made it more likely that Mr. Clark did not do the second robbery. And I see I'm out of time, but I just wanted to end with saying that Mr. Clark is possibly wrongly convicted for all of the crimes, but there's also this reasonable probability that he would not have been convicted for one of them. And that's extremely significant in this case. And it is based on the DNA and the eyewitness identification evidence that really should never have come out, or should have at least been countered by an expert during trial. And under Kagosi, the reasonable probability of a different outcome is measured by whether or not it would raise reasonable doubt in the jurors' minds. And this evidence, this identification evidence and the DNA evidence would definitely have raised reasonable doubts. And for those reasons,
And in your view, the one that he most likely would not have been convicted of is which one?
I believe it would have been.
Which one is more likely?
I believe the first one would have been, it would have been more likely. The second one, it was very much less likely. Had Mr. Cornell Hilton not put him behind, it actually identified him as the second robber. But as far as the first robbery and the Cornell Scott's property in his pocket, this could have been a simple case of, other people, the actual robbers handed him the evidence. He stuck it in his pocket. He may have not done the second robbery. That there's no identification of him doing the first robbery. There's different, descriptions of clothing. But
am I wrong though? It sounds like you kind of have to argue that the evidence is likely to, or creates a reasonable probability that he wouldn't have been convicted of either, right? I mean, because if he has evidence from the first robbery in his pocket, that's, sort of implicates him in the first robbery. And then but the idea is that he gets picked up for the second robbery, but doesn't participate in that or the first robbery. But you see what I'm saying? Like, it doesn't seem to quite match up that I thought the argument below was that it was innocent presence in the car for the second robbery, but I didn't realize that he had proceeds from the first robbery in his pocket. I thought the proceeds were from the second robbery. So I'm not quite following how you're parsing the evidence, I guess is what I'm saying.
I believe the defense at trial was innocent presence, period. That he was just in the car when the first robbery happened. He wasn't a participant in the robbery. And then for the second robbery, again, he was just in the car. He didn't agree with going back. There's no conspiracy on his part.
Okay, so he's not there for the first one and he's innocently present for the second one. But now on appeal, you're arguing that you have a stronger case to say there's a reasonable probability of a different result as to one crime or the other. And I'm just trying to, I guess I'm going back to Judge Thompson's question. I'm not sure which one you're saying there's a stronger reasonable probability showing.
I think with the question that Judge Thompson asked me, it sounded like If you consider what the evidence that she asked me about, then I guess it would be stronger with regards to the second robbery. But I think we have to look at is not what I think, but what the jurors would have thought.
I'm just asking what the argument is. And, are you asking this court to conclude that there's a reasonable probability of a different result as to both crimes, or just one, and if just one, which?
Oh, as to all of the crimes. There's definitely a reasonable probability as to all of the crimes. But I also want to keep in mind that this court could find that with respect to one of the crimes, there would be a reasonable probability, even if it's not respect to all of the crimes, definitely with respect to, for example, the second robbery. Because that would have changed the outcome of the trial.
Right. I think we understand your argument. Thank you, Ms. Walton. Thanks to you also, Mr. Williams, Ms. Kalu. The case is submitted and you may now exit our remote courtroom. Thank you.
Thank you, Your Honors.
Thank you.
I will call our second case, which is DC Metropolitan Police Department versus DC Public Employee Relations Board. It is number 19 CV 1115. And I see Mr. Simpson. I don't yet see Mr. McCartan. I now see Ms. Anderson. All right, I think we might all be here. Good morning, counsel. Ms. Anderson, I think we go to you, correct?
That's correct, Your Honor. Thank you. Good morning. May it please the court. Stacey Anderson on behalf of the Metropolitan Police Department. With the court's permission, I would like to reserve 3 minutes for rebuttal. Your Honors, MPD fired Thomas after he used nearly lethal deadly force by shooting an unarmed man twice. The man posed no threat and he committed no crime. Although agreeing with these facts and concluding that Thomas's conduct was reckless, objectively unreasonable, and even criminal, the arbitrator nevertheless set aside MPD's termination decision and imposed his own 45-day unconditional suspension. Under the CMPA, this court can set aside an arbitration award that on its face is contrary to law and public policy.
Can I just ask you, you may be skipping a step. I don't think the CMPA, that provision is addressed to the court. I thought that provision was addressed to PERB, and we review PERB's determinations under principles of administrative law. Or am I missing?
No, you're correct, Your Honor. You're certain that is absolutely correct, and we are asserting here that PERB's decision is incorrect as a matter of law and failing to recognize that the arbitrator's decision is contrary to law and public policy in 2 respects.
Can I ask, before you get into that, just to stay on the framework for a minute, because I find it pretty confusing. I mean, maybe that you were treating it as a pass-through because you think we don't owe any deference to PERB's interpretation of the provision about PERB's authority to set aside arbitral awards. Is that your position, that we owe no deference to PERB, or do you think we owe, I mean, your opponent argues we owe extra special deference and it has to be kind of super Chevron type deference, where it has to be rationally indefensible. At times, your brief seems to suggest we owe none. And so I want to make sure I understand what your position is and why you think it. Do you think we have do we owe PERB the same deference with respect to the interpretation of that statute that we generally give agencies when they're interpreting statutes they administer?
Yes, Your Honor, you do owe that same deference. I don't disagree with that whatsoever. But this court has recognized that PERB has established the standard here for when you set aside an arbitrator's award that's contrary to law and public policy. So PERB has applied that standard, and this court has acknowledged that PERB has recognized that that is an appropriate circumstance in which an award would be set aside. So here the question then becomes, did PERB properly analyze that question under its own standards? And here it did not. It actually failed to altogether discuss the arguments that MPD presented to it. It kind of simply dismissed them as simply being mere disagreements with the arbitrator's decision, and that's simply not the case. We don't merely disagree with his decision. He committed errors of law that on the face of his award are contrary to law and public policy in 2 respects. And I'd like to
I apologize to keep interrupting you before you get to the meat of what you're trying to say, but there are lots of layers of potential deference here, and I think it's helpful to make sure I understand people's positions on all of them. So you say PERB has expressed a standard about how freely or not freely it will set aside arbitral awards under this language about on its face, contrary to law and public policy. Could you tell me what you think that standard is that PERB has articulated that we should hold PERB to?
Sure, certainly, Your Honor. That standard is that when an arbitrator looks to external law and considers that law to be controlling and applies that law, but overlooks or ignores an express provision of that law, then his decision is contrary to that. So in our case, the arbitrator did look to external law. He was charged in this case with deciding whether or not MPD's penalty determination was contrary to Douglas. And it was explicitly charged with that.
Let me ask you about that and just interrupt you. I'm sorry for interrupting your answer to Judge McLeese's question, but where do we find what the arbitrator was charged with? I looked at the parties' briefs before the arbitrator, and each party asked the arbitrator to decide whether termination was an appropriate penalty.
Right.
Is there some other document where the arbitrator was charged with looking at Douglas and figuring out whether Douglas was properly applied?
Sure, Your Honor. I think, yes, that's correct. The general overarching issue that the arbitrator was to decide was whether termination was an appropriate penalty. But when you look at the briefing, the arbitrator was asked to make that determination based on Douglas. And I will point the court to the specific pages in the joint appendix. FOP's opening arbitration brief, JA 1029 to 1030. FOP's reply brief before the arbitrator, JA 1076 to 77. And that position was consistent. So when we get to PERB, this is what FOP says about what the arbitrator or what was submitted to the arbitrator. So FOP says, pursuant to the terms of their collective bargaining agreement, the CBA, the parties submitted two issues for the arbitrator's determination, including whether the department's termination of Douglas was an appropriate penalty under the analysis of Douglas.
Can I ask you?
JA 1111. And then when we get to the superior, I'm sorry, Judge McLeese, did you have a question?
Let's take as a given for a minute that the parties teed up to the arbitrator the question of whether this was appropriate under Douglas. There is a related aspect that seems to be a matter of contention, both about what the arbitrator should do and about what the parties wanted the arbitrator to do, which is when it was assessing the Douglas factors, was the arbitrator's job, yet another layer of possible deference, was the arbitrator's job to kind of de novo look at those factors and say, what do I, as the arbitrator, think is the appropriate penalty under Douglas? Or was the arbitrator's job to defer and instead say, it's really not up to me whether in the first instance that's the penalty I would pick, but rather my job is to see whether MPD, having chosen to do that, that's kind of a reasonable application of the Douglas factors.
It's the latter, Your Honor. It's the latter. So under the collective bargaining agreement, the arbitrator sits as an appellate review, or serves an appellate review function. It does not consider the matter de novo. And again, I think that was undisputed in FOP's briefing. In fact,
just to make sure, I mean, that's a somewhat abstract sort of support for your position about what the right answer is, about what the arbitrator's function was. And what PERBs, and the arbitrator, to me, the arbitral award is somewhat inconsistent about that. At times, it seems to be reflecting a de novo attitude. And at times, it seems to be expressly saying it's instead kind of looking for what's reasonable. So I find the arbitral award itself somewhat unclear about that. But for a minute, leaving aside what the parties said at all the various stages of this litigation, but instead what PERB said, what PERB has said about that is, MPD, you keep telling us that the arbitrator has to defer to MPD in figuring out the proper penalty. We've told you a million times that's not right. That's not our understanding of what the arbitrator is required to do. Do you agree that's what PERB said?
Yeah, And again, Your Honor, yes, and I want to be clear as to what I'm asking the court to do here. I'm not asking the court, for example, I'm not challenging the arbitrator's findings on factors 10 and 12 because they're not contrary to law. There's a lot of judgment that goes into making a Douglas determination, and I can't point to a specific law that would preclude the arbitrator from reaching those conclusions. So we're not challenging him here.
But are you asking the court to say the following? PERB in this decision and in prior ones has said that its understanding of the law is that arbitrators can kind of pick the penalty themselves rather than having to defer to MPD. And are you asking us to say, PERB said that, but that's just wrong as a matter of law. Don't give Chevron type deference to it. That's just wrong. Or
No, Your
should
Honor.
we be deferring to PERB on that topic?
No, Your Honor, I'm not asking for that either. Your Honor, the difficulty here is that the arbitrator didn't do the proper weighing. And if you look at Joint Appendix 1156, this is what PERB said about the arbitrator's role. It says, the arbitrator next determined whether termination was an appropriate remedy. Douglas versus Veterans Administration requires 12 factors to be weighed in determining whether an agency's penalty in an adverse action case was reasonable. So it's the issue of the weighing. The weighing here didn't happen, and that's our issue. Douglas requires the weighing. PERB recognizes that Douglas requires the weighing, and the arbitrator simply failed to do his job. He didn't weigh.
But just to be clear, leaving aside what you're asking us, what is your position about the following? There is a statement in PERB's decision in this case, and it refers to prior PERB decisions that says the following. Arbitrators handling the cases arising under this collective bargaining agreement and conducting an inquiry into appropriateness of penalty under Douglas are not required to defer to MPD's view about what the reasonable penalty was. Do you think that is a correct statement in PERB's decision, or is it an incorrect statement in PERB's decision?
I think it's a generally correct statement, Your Honor. And here, I guess maybe if I articulate.
You say generally correct. I want to make sure I heard you correctly. Did you say generally correct? Generally
So, Your
correct.
Honor, as to each factor, I think the arbitrator's determination is binding. The example I was giving you as to factor 10 and 12, we're stuck with that. I disagree with it. This court may have reached a totally different conclusion had it been before it, but the arbitrator, I agree, we owe deference to that. We have to accept those findings. Okay, so as to each.
But my question is more broad than that. It's very abstract. It's a general legal question, which is PERB says the arbitrator's job in these cases is to weigh the Williams factors for the, de novo for the arbitrator. That's what PERB says the arbitrator's function is.
I disagree that.
I know you think we may not have to decide that question to rule in your favor in this case.
Right.
But
No,
my question is that do you have a position on whether that's a correct legal statement by PERB or one that we should be deferring to? That general idea about what the function of the arbitrator is in these cases, is PERB right about that, or you don't agree, but you think we have to defer to PERB, or what do you do about that general assertion?
So, Your Honor, I think once PERB concludes that MPD did not properly weigh the Douglas factors, then yes, the arbitrator then has the authority to choose a penalty he believes is the correct penalty. But
I'm not sure that's not what PERB said. So you're saying here's a legal principle that's different from what PERB said that you agree with. But what PERB said, what I understood PERB to say was, just generally, the job of an arbitrator is for himself or herself, just apply the Williams factors. And you can look and consider what MPD did, but you figure it out for yourself and make your own decision. And my question is, do you think that is both wrong and something we shouldn't be deferring to in PERB's opinion?
I disagree that that's what the parties asked the arbitrator to do in this case.
That's not my question.
Well, Your Honor,
my question.
Your Honor, then I disagree with it.
Okay.
I disagree with that statement.
Clear.
Because,
no, hold on for a minute. Just to be very clear, I'm asking you what your position is on a legal principle, which is it right or wrong as a matter of law that an arbitrator under this collective bargaining agreement reviewing a employee discipline determination should always, the function is figure out yourself, arbitrator, what you think is the best weighing of the Williams, the Douglas factors.
I disagree with that.
You disagree with that. That's what
I disagree with that, Your Honor.
Thank you.
I think it's again, under Douglas, it's a two-step analysis. It's whether or not the agency's penalty was on balance within the tolerable limits of reasonableness, which is for the arbitrator to determine. And if the arbitrator determines that it was not within the tolerable bounds of, or within the the tolerable bounds of reasonableness, then it becomes the arbitrator's job himself to select a penalty. And here, our point is the arbitrator didn't make the necessary findings in the first step to set aside MPD's penalty determination. And I'm going back to the collective bargaining agreement and what the parties asked the arbitrator to do here. He sits as an appellate function. He's limited to reviewing the record that was made before the adverse action panel. And and as FOP framed it, he's reviewing for substantial evidence in the record. So that is an appellate standard.
Do you have before you the appendix, a page site for the appellate review function?
It's in the, yes, Your Honor.
In
I
the
apologize.
collective bargaining agreement?
Right, I think it's supplemental appendix page 13, but I'm not 100% positive, but I can certainly find that for you.
All right.
And it's definitely cited in my brief, and I apologize, I don't have the pinpoint site for you.
The comments you're making are focused on factual determinations, at least some of them, like review for clear error, are limited to the factual created and the like. You're not suggesting, are you, that what the appropriate sanction is a question of historical fact that reviewed for clear error, are you?
No, not at all. Again, Your Honor, I'm not asking for review of factual findings or under a clear error standard or any other standard. Had the arbitrator found, for example, again, I'm going back to Douglas factors 10 and 12. We're not challenging those because they're not assailable here because they do involve factual findings. Our point here is that what the shortcoming here was the arbitrator didn't do what he needed to do. He didn't reach the merits of the question because he didn't balance the 12 factors and determine that MPD's penalty was outside the bounds of tolerable reasonableness that Douglas requires. He just didn't do that. And then in assessing his own penalty, which he's free to do, but he's still required under Douglas to consider the 12 factors. And we know he didn't consider the 12 factors here because he said so. He said the only thing he based his penalty on was the penalty that Ford received. So he didn't do what Douglas commands. And that's all we're asking the court to find, not to overturn any factual findings, not to if he had disagreed that the 7 of the 12 factors were aggravating and found them to have been mitigating, again, that would not be something that we can necessarily challenge.
What remedy, I was about to go check your brief, but it may be shorter to just ask you. The logic of what you just said suggests that the matter should be remanded to the Superior Court, to remanded to PERB, to remand to the arbitrator, for the arbitrator to do what you think the arbitrator was required to do by the law the arbitrator pointed to. Is that the relief you're asking for?
No, Your Honor, I'm not. I'm asking for the court to impose the same relief it imposed in MPD versus OEA, which I know there's a bazillion of them. So it's the 88 3rd 724 case.
Can you say that site again?
Sure, 88 3rd 724. It's MPD versus OEA. In that case, again, it was an OEA case, but my point doesn't turn on whether or not it was OEA or the arbitrator. There, OEA did exactly what the arbitrator did here. The OEA failed to apply the Douglas factors correctly and weigh the factors and to overturn MPD's termination decision. In that case, it was an outright reversal. I've checked the Superior Court docket. It wasn't remanded to the Superior Court. Nothing's taken place in the case since the court's decision in 2014. It was an outright reversal. And I think that's understandable because the arbitrator had his opportunity here to find a flaw in MPD's decision, and he failed to find it. It's an error of law. It's no different than any other case.
I thought you were conceding. I thought you were conceding that you're not disputing some of the disagreements the arbitrator had with MPD's application of the Williams factors. So I thought that from your earlier comments, you were agreeing that although generally an arbitrator is stuck with deferring to what MPD does in settings like this, the arbitrator here wasn't, because the arbitrator found some mistakes that you're not disputing, but then your further complaint is then the arbitrator didn't do what the arbitrator would have to do on that theory, which is actually conduct the Douglas balancing. Am I missing?
Yeah,
something?
No, that's right. I mean, that's my point. Under Douglas, if you find flaws in the agency's consideration of 1, 2, 3, 4 factors, that's not the end of the inquiry. The reviewer goes back and then says, okay, notwithstanding my disagreement with those factors, was the penalty imposed by the agency still within the tolerable bounds of reasonableness? And so you look at here, the 7 other aggravating factors, and the arbitrator is supposed to ask himself on balance, can I say that, where we disagree is enough to say that termination was out, was off the table. That
So are you
could
saying,
reasonably,
I'm sorry, Ms. Anderson for interrupting, but are you saying that remand isn't required because as a matter of law, no one could find the Douglas factor calculation favored the FOP's determination that the only reasonable assessment of the Douglas factors supported the discipline that was imposed in this case?
not necessarily, Your Honor, no. What I'm saying is the arbitrator had his opportunity. He was unable to come up with a valid reason for overturning MPD's termination decision, and that should end the inquiry. If the court's inclined to
But
remand.
I guess I'm missing, I just don't know enough about arbitration, but I'm wondering why that should be the end of the inquiry. Because my understanding is that both parties have agreed to arbitration, so it's not just like a one shot and you're done kind of enterprise, right?
Right.
And so if the arbitration didn't go well, wasn't conducted properly, the arbitrator didn't do their job. Say that there was some procedural requirement that the arbitrator, like there was supposed to be a hearing and the arbitrator just whipped off a decision, wrote it, and we were on appeal here. I don't think you'd be arguing to us, well, the arbitrator didn't have a hearing and so reached a wrong decision without adequate basis, and so reinstate the MPD's determination. You'd say, well, send it back. And I'm struggling to see why this is different.
Right, Your Honor, it wasn't a procedural error, it was a substantive error. But I understand the difficulty, which would bring me to my second point is, our alternative basis for relief is that anything short of termination would be contrary to public policy, not because the arbitrator violated Douglas in any respect, but just simply because a suspension like the one proposed here would be contrary to the dominant, well-defined, explicit public policy against the excessive use of police force.
Can I ask you,
I was going to ask you that question because you said a little earlier that if the arbitrator did the weighing that he was supposed to do and he found that the penalty was not within the tolerable bounds of reasonableness, then his next step would be to select a penalty. And here, all he did was base the penalty on the penalty that Officer Ford received. And my question to you was going to be, well, is it MPD's position that no other penalty would be consistent with public policy? No penalty other than?
Yes, on the facts of this case, Your Honor, correct. If the arbitrator had followed all those steps, we would have 1 point on appeal, which would be our public policy argument. We would not be challenging necessarily his Douglas analysis. Had he done.
Can you explain? Imagine that instead of shooting the victim twice, the Officer Thomas had shoved the victim without justification. So it would be violating the firmly rooted public policy against the excessive use of force by police officers. Would you say that on the facts of there's just like a flat rule? If an officer violates that, the set of laws, and assume that was criminal, a less serious crime, simple assault, let's say, but assume it's all, everything's the same except the gravity of the crime and the gravity of the injuries. Important differences for sure, the gravity of the injuries. But are you saying it's just always against public policy to do anything other than terminating an officer who uses excessive force in the line of duty in a way that amounts to a crime?
No, Your Honor, we're not asking for that broad of a holding in this case. What we're asking the court to hold is that there's a public policy against the excessive use of deadly police force that we have here. We are very comfortable with the court, a narrow decision.
You think that's a stronger public policy? You think that's a stronger public policy? They're both. I assume you think it's an important public policy that your officers not use non-deadly excessive force.
Certainly, Your Honor, but the dominant, defined, explicit. We're not asking the court, and I think in other cases, perhaps the court's already addressed a more generalized concern with criminal conduct by police officers. But our point here is that this is an extreme case of excessive force where an officer shot an unarmed man for no reason. And it's our position that the policy against the excessive use of deadly force mandates that the Metropolitan Police Department be able to terminate that officer. The 45-day suspension that was imposed here, it does nothing to deter similar misconduct by other officers. It does nothing to ensure that Mr. Thomas is no longer a threat to the citizens of the District of Columbia. And given the extreme circumstances of this case, and I'm not asking this court to do anything that sister courts across the country have already done. The City of Seattle case that came down in May 2021 from the Court of Appeals in Washington, the analysis I've offered here is precisely what the court adopted there, recognizes that in instances where police engage in excessive, extreme physical misconduct, as here, that termination is the only acceptable response in the interest of public policy. And so, yes, that is our position here.
Ms. Anderson, thank you. We'll give you a few moments on rebuttal, but let's hear from your opponents. And let me ask Mr. Simpson and Mr. McCartan how they have agreed to divide their time.
Thank you. We've agreed to divide our time 8 minutes apiece. I think it's how the math turns out. I will be going first.
All right. Well, you may proceed then. Thank you.
My name is Daniel McCartan on behalf of the DC Police Union. This case was sent to arbitration pursuant to the collective bargaining agreement between the Metropolitan Police Department and the DC Police Union. After the Chief of Police made final agency action in this case and terminated Officer Thomas, that triggered the right to arbitrate the matter. The parties have agreed to send disciplinary matters to arbitrators in their collective bargaining agreement. Pursuant to that agreement, as was referenced in the department's oral argument, the CBA states in Article 19 under arbitration that the arbitrator shall confine his decision solely to the precise issue submitted for arbitration. There were 2 issues submitted to arbitration, and those issues are found throughout the record. In the FOP's arbitration brief at page 995 of the record, in the MPD's arbitration brief at 1042 of the record, and also in the arbitration award on pages 19 and 24. And those issues were whether the evidence presented was sufficient to support the charges, and number 2, whether termination was an appropriate penalty. The arbitrator confined his decision to those 2 issues as required by the CBA and determined that termination was not an appropriate penalty.
Can I ask you, that way of framing the issues is kind of abstract, and the word appropriate is kind of ambiguous. And so your opponent argues that if you dig a little deeper and you look to the filing that folks submitted in to the arbitrator, that will find that the police, the FOP, was asking, at least some of the time, was suggesting that the arbitrator should be applying the Douglas factors in making that determination, A, and B, should be complying with the aspect of Douglas, which is kind of builds in deference to the agency determination by saying that the inquiry is whether the discipline is within the realm of reasonableness. That's a paraphrase. Do you disagree that the filings that were submitted in front of the arbitrator by your client reflect those more specific understandings about how to figure out whether a penalty was appropriate?
No, I don't completely disagree with that, Your Honor. The parties submitted to the arbitrator in that section on whether or not termination was an appropriate remedy. Much of the analysis and much of the argument centered on analyzing the Douglas factors, because those Douglas factors have been used in courts, have been used in processes, and have been used by the parties to determine whether or not a certain penalty is appropriate based upon conduct. And so based upon those Douglas factors that the arbitrator used, and he also, if you look on page 25, he explains, the arbitrator does, that the Douglas factors are relevant, but that also outside of the Douglas factors, when you look at generally the degree of discipline, you can look at other factors, and he looked at other factors, including he references subsequent books discussing discipline, consider other factors that aren't necessarily Douglas factors, but the grievance record, years of employment, unequal discriminatory treatment, things of that nature.
Focusing back on what the parties asked the arbitrator to do, was there any place where either party asked the arbitrator either to de novo apply the Douglas factors, or to, independent of Douglas, just kind of make the arbitrator's own judgment based on other possible materials about what penalty was appropriate? Is there any place in the filings in front of the arbitrator that where anybody asked the arbitrator to do either of those two things?
Yes, in the union's arbitration brief, they, I believe, went through all of the Douglas factors and asked the arbitrator to make his own determinations on the Douglas factors. The panel asked this question in direct, and in the lower court and in PERB, the MPD requested that the arbitrator and PERB and the Superior Court apply the deferential standard in Stokes that applies to the OEA's application of the Douglas factors. And PERB and the Superior Court both said that that standard does not apply, that instead the arbitrator is empowered, because this is through contract, not through an appeal through OEA and the CMPA, that the arbitrator is empowered to review the Douglas factors on his own, de novo. And so—
Can you go back to, you said that the FOP definitely asked the arbitrator to conduct de novo review.
Well, I don't know if they used the words de novo, Your Honor, but I believe they went through all the Douglas factors and presented them to the arbitrator and explained why they—
Just going through the Douglas factors, I mean, the arbitrator on page 23 says, this is what the FOP's argument is, right? As there are other arguments about whether or not there should be any discipline at all.
Mhm.
But as for what the sanction should be, number 5, the arbitrator says that FOP's argument is that termination isn't appropriate because the panel didn't properly weigh the factors required by Douglas, right? So that sounds like the arbitrator understands FOP to be saying, not please do it afresh, anew, de novo, however you want to characterize it, but please look at what the panel did to see whether they did it correctly.
Mhm.
And I'm wondering where in FOP's pleadings it indicates that FOP wanted the arbitrator to do more than that, because it doesn't sound, at least from page 23, that the arbitrator understood that it was being asked to do more.
Well, I believe in the brief, the FOP requested that, well, they did argue that the panel didn't properly apply Douglas, but they also argued that, for example, citing to the Ford case and to 2 other comparable disciplinary cases, they asked the arbitrator to determine that in his powers, that the termination was not an appropriate penalty. And that in combination, number 1, the panel did not appropriately consider those factors, but on top of that, there was basis that they provided to the arbitrator to explain why he should rule differently on that Douglas factor. And so I think what's important in the argument of the MPD, they have stated that they do not challenge the arbitrator's finding on Douglas factors 10 and 12. Well, if you look at the arbitrator's decision, he specifically says on page 27, I find for these reasons that the panel did not reach conclusions on Douglas factors 7, 10, and 12 within the tolerable limits of reasonableness. And so when he finds that—
I want to just glom onto one of those, some of those words, the last few you mentioned, because I interrupted you when you were going to talk about what the arbitrator thought the arbitrator was doing in terms of deferring or not deferring to the agency's determinations under Douglas. And I see some indications going both ways, but one of the ones that seems to suggest the arbitrator was deferring is the language you just described, the last few words of which are, within a tolerable range of reasonableness. If the arbitrator's real job under the collective bargaining agreement is not to really care too much about what MPD thought, but instead to kind of de novo figure out, well, what are, there's this Douglas factor, I'm going to apply them and I'll figure out how they point. I don't really need to worry too much about MPD's thinking. I don't need to defer to it. I don't need to care about it. Then why is the arbitrator saying what the arbitrator just said in the language you quoted, which is, I'm going to look and see whether MPD's analysis of all this is within reason. That seems more to reflect a deferential attitude rather than a de novo one.
I believe he would not have had to have made that determination specifically in order to reach the answer to the issue presented to him, which was whether termination was an appropriate remedy. However, he did, and he applied Douglas, and Douglas specifically states that not all of
applying Douglas, that gets us confused. I mean, or it doesn't respond to the question that Judge McLeese has and I have as well, right? I mean, you can apply Douglas. You can apply Douglas yourself, or you can look at Douglas as it was applied by the MPD and say, well, how did they apply Douglas? Now I'm going to go through Douglas and make sure that they did it right, right? So the question is, what did the arbitrator understand that he was doing? And to the extent that he seemed to be pointing in different directions, maybe we just need to remand because it's not clear that he had a clear understanding of what he was doing.
Well, it does. His decision did review certainly, and he goes through each of the department's Douglas factor findings. He reviewed each of those, and he determined which ones he believed, if any, fell within the tolerable limits of reasonableness. So he did review that decision.
And where's the part where he then said, I mean, so what do you think he thought he was doing once he got to that point? So let's say the arbitrator says, one thing I want to do here is look to see how MPD applied the Douglas factors. I think they got, 3 wrong and 9 right. Now, ... Do you think the arbitrator then said, okay, if I've checked the box, MPD didn't do it right. Now I'm going to figure out the appropriate penalty and I'm not even going to worry about Douglas? Or do you think the arbitrator was thinking, okay, I checked the box, MPD didn't do it right. Now I'm going to do Douglas and balance all the factors. Or do you think, what do you think the arbitrator was doing once the arbitrator checked the box of saying, look, MPD didn't really do the Douglas inquiry correctly? Now what?
Yeah, I believe he reviewed the MPD's Douglas factor analysis. He found that 3 of the Douglas factors they did not do correctly. And then he applied those Douglas factors in a way that he believed resulted in an appropriate penalty.
Where did he apply it?
He applied it on,
the analysis just ends on page 27.
He applied it on page 27, where he states that he applies Douglas factor 7 at the top, in the middle of the page. And where he says that in the Ford case, Ford's termination and shooting after he identified himself as a police officer was converted to a suspension of 45 days. So Douglas factor 7 contemplates whether or not comparable discipline shows.
Right, that's just one factor, I guess is my point, right? And so there are
12,
a dozen Douglas factors, and he has problems with 3 of them, but it doesn't seem like there's a reassessment then of the totality. It just stops. So to the extent that he is, either reviewing what MPD did or doing his own analysis anew, his analysis seems incomplete.
Well, I don't believe there's any requirement that he then redo an entire Douglas factor analysis. He found that the Douglas factors analysis already done was appropriate for the other 9 Douglas factors, and he only addressed the 3 that were pertinent, as Douglas says, not all.
But don't you think that he needs to say at least something? Maybe he doesn't have to tick through each one of them, but doesn't he have to say then, okay, then considering all of these other Douglas factors that I think were appropriate or appropriately evaluated, and these 3 that I think were inappropriately evaluated, I come to a completely different conclusion, right? Not termination, but a 45-day suspension. That requires a little bit of explication, don't you think? if you're saying 9 factors stand, but 3 are different, and suddenly I'm going to shift quite drastically in what the sanction should be.
Well, in doing that, he did quote Douglas prior to getting into the Douglas factor analysis. And he did say that selection of an appropriate penalty involves a balancing of the factors in an individual case. He stated that only the factors, not every factor will be relevant in every case in determining what an appropriate penalty is.
You're talking about earlier in the.
Correct. As he turns to the second issue on page 24, and he quotes from Douglas saying that not all the factors will be pertinent in every case. He recites what the department did in their Douglas factor analysis. And he cites that he says here on the page 25, essentially the panel used the same language used in the initial notice. I do not conclude that using the same notice after an exhaustive review means that the panel and the chief did not consider all the other factors.
But I get all of that, but if this were an agency decision, speaking for myself, I would think it was inadequately reasoned. Either if the arbitrator thought, okay, MPD misapplied Douglas, so I can do what I want, and here's why I think 45 days is appropriate. I don't see either of those last two things. So if that was what was going on, it hasn't been explained. If the arbitrator instead thought, okay, I disagree with MPD's application of 3 of them, and I think once I fix those mistakes, I think the overall right sanction is 45 days. If that's what was going on, I don't think that's very well explained. And if part of it is, well, I'm going to pick 45 days because I'm not saying this case is similar, but it's the most similar, and that's the sanction there. If that were the reasoning in an agency decision, I would think it's not good enough. That's speaking for myself. Now, I fully recognize that we're not reviewing an agency determination. We are reviewing an arbitral decision that is subject to review by PERB, to whom we defer. So there's, that may end up changing things. But your opponent argues that PERB has said, in other cases at least, that where an arbitrator says, I'm going to apply some law, and then it ignores or overlooks that law, that's when PERB will step in and say, our arbitrator, that we're not going to enforce that award. And they're claiming that that's what happened here. Why aren't they right? That, it seems like the arbitrator says, I'm going to do Douglas. And then instead the arbitrator says, I think MPD did 3 parts of Douglas wrong, and I'm picking 45 days for a reason that isn't necessarily that persuasive on its own terms. So why isn't that something where PERB was obliged under its own standard to step in and tell the arbitrator either, no, that's not a reasonable outcome, or in any event, you haven't, this is not a valid arbitral award because on its face, it's contrary to law because it referred to external law and then ignored or overlooked it.
Yes, thank you, Your Honor. The arbitration award did refer to external law, but the arbitration award does not violate external law on its face. And that's why PERB affirmed it. The reason being, it is consistent with Douglas. Douglas says not all factors will be pertinent in every case. The arbitrator applied that and applied what he believed to be the pertinent factors. Douglas says the ultimate burden is on the agency to persuade that the penalty was reasonable. He said that the agency did not reach that burden.
Can I ask you a hypothetical? Imagine everything about this case is exactly the same, except the underlying conduct was that the officer in question had, instead of the incident that happened here, had walked into the police station and had in cold blood murdered, a bunch of people in there, people going about their business and other officers. Everything else about the case is the same. MPD, says the same thing about the Douglas factors, and the only case anybody points to that is comparable is the Ford case. And the arbitrator wrote an opinion that's exactly says all you could say pretty much every word in here. Would you say if the arbitrator chose to impose a 45-day penalty, that PERB either would be powerless to fix it, or in any event, if PERB chose not to fix it, this court would be powerless to say that's just not a no reasonable person could think that reinstatement in that setting, much less only a 45-day suspension, is a reasonable penalty.
Yes, and I believe Herb would not be able to overturn it, nor would the court. And that bleeds into
Just to make clear, on the hypothetical I just gave you, you think that if an arbitrator chose to reinstate somebody in that setting, there's nothing that either Herb or this court could do. That's your answer.
Yes. And my answer responds to the department's, that bleeds into the department's public policy argument. And the public policy argument that they've cited deals with excessive force. The Seattle case that they've cited dealt with someone who was engaged in excessive force in the line of duty. Officer Thomas was not in the line of duty in this case. So that body of cases against the use of excessive force by police officers in the line of duty is not applicable here. In this case, they've also in their briefing.
The complaint was that it's worse that he wasn't in the line of duty because he had no police authority and he was asserting that he had it and was giving orders that he was not in a position to give. So I'm not sure why that difference necessarily helps your case or hurts it relative to the Seattle case.
Well, I think I think it helps because the case law that they've cited doesn't deal with off-duty incidents. It deals only with on-duty incidents. And so
but doesn't it undermine the choice of a 45-day suspension? I mean, because that's the difference between Ford and your client.
No, it's not. Officer Ford was also off duty. I think that's significant. So,
but he was in a jurisdiction where he worked and where he had police authority, correct?
Officer Ford?
Yes.
It occurred, I believe, in the District of Columbia. But what's significant in the Ford case, and the department cites to the Ford case and attempts to factually distinguish it, but both officers were off duty. Both officers engaged in use of force. If you look at the record.
One was acting, I thought, arguably in self-defense, and I think there's zero claim of self-defense for Mr. Thomas.
No, absolutely.
He actively engaged he accosted the victim in this case.
Officer Thomas argued throughout the proceedings that he was acting in self-defense. He brought in a use of force expert.
And that was not credited, and I don't think anybody has disputed that determination, right? I mean, the arbitrator doesn't take issue with those factual findings. The arbitrator does not say that Officer Thomas was acting in self-defense in this case. Am I right?
He does not. But
in fact, I mean, I think he says the facts are what they are, or what the MPD found.
He did not. Yes, the trial board did not find that Officer Thomas was acting in self-defense, but he maintained that he was.
And it's not just they didn't find it; they rejected that. And the arbitrator accepts that determination. I think you're stuck with that, right? But is the FOP's argument essentially, look, MPD agreed to arbitration. You made your bed. You get what the arbitrator says, no matter how arbitrary the arbitrator is. And that's it. This is our little escape hatch so that, any police officer discipline, that you try to enforce, we get to take it to arbitration. We can get completely arbitrary arbitrator rulings and get our police officer members off the hook. Is that what FOP's argument is at its core?
I wouldn't say at its core. Yes, certainly the position is that the parties have agreed by contract to bring these matters to an arbitrator. And I think what's key is this has come up many times.
I guess I'm curious, what is the meaningful review of the arbitrator's award? If we can look at this award, which this reasoning is incomplete and not terribly coherent. And if Herb can affirm this and we have no ability to reverse Herb, then what meaningful review really is there of these awards? I'm just trying to figure out what's FOP's view on how these awards can be reviewed.
There is a review, and that review is defined by the CMPA. If the arbitrator acted outside of their jurisdiction, for example, answered an issue that wasn't posed to him, then that could be overturned.
Well, arguably, this arbitrator was answering a question that wasn't posed to him. It seems like FOP just asked him to find that the MPD panel had misapplied the Douglas factors. The FOP,
FOP
I'm
asked-
not seeing any indication that the FOP asked the arbitrator to do this all over again.
The FOP asked him to determine what the appropriate remedy was. And that was analyzed through the Douglas factors. Before I get away from the Ford case, I would also say on page 989 of the record, Officer Ford shot and killed someone, and the department's use of force review board, as in this case, found that that shooting was unjustified. And the department
But
itself,
unlike this case, no one found that no one alleged that it was criminal, right?
pardon me?
I thought, unlike this case in Ford, no one alleged, much less found, that Officer Ford's conduct was criminal. Whereas in your case, the MPD found that your client's conduct was reckless endangerment under Maryland law, and the arbitrator agreed with that, affirmed that conclusion. So that seems like a pretty substantial difference between the two matters.
They were charged with the same
No
violation.
matter what they were charged with.
Okay.
We need
But I
to,
think it's true. Is it right? I thought there was no specification in Officer Ford's case. I'm not sure of this, but I thought there was not a specification of criminal conduct. There is a specification in common. They both were charged with violating the excessive force regulations or rules. But I thought in your case, unlike Officer Ford's, there was an allegation also of criminal conduct and a determination that in fact criminal conduct occurred. And I didn't think there was an allegation of that in Ford, much less again a determination that criminal conduct occurred.
That's accurate. And the charge in this case was conduct that could constitute a crime. Importantly, Officer Thomas was never charged with a crime, was never arrested, was never convicted. The Maryland authorities and the Maryland State Attorney reviewed the matter and chose not to impose any criminal charges. But yes, you are correct. There was an additional administrative charge against Officer Thomas, which states that conduct that could constitute a crime. And it was based on the same conduct as the failure to obey orders and directives, which was the second charge.
You were starting to say that the arbitrator was asked to determine what was an appropriate penalty. The issues identified in the parties' briefs was whether termination was an appropriate penalty. Do you, I think, maybe I'm misremembering that. Do you view those as the same question? In other words, would the arbitrator have done his job if he determined that termination was not and just stopped there and left it to MPD to figure out what would be an appropriate penalty? Or do you think what is an appropriate penalty was implicit in the charge to the arbitrator?
You are correct. It was whether termination is an appropriate penalty. I think it was implied that if he found that it was not an appropriate penalty, that the parties would want him to apply an appropriate penalty.
It was expressed in your brief to the arbitrator, in your prayer for relief at the end. It was expressed in the alternative that you wanted the penalty recommendation to be reduced from termination to a reasonable suspension in conformity with other similarly situated officers. And since you've been arguing that Mr. Ford was a similarly situated officer, I do think you preserved the argument to the arbitrator that the arbitrator could end up, whatever the arbitrator thought his function was, the arbitrator could, in the alternative, end up at a 45-day suspension in lieu of termination. Your principal request was you're arguing that the record didn't support determinations of misconduct and you wanted the whole thing set aside. But I think you, at least on that point, I think you preserved that point to the arbitrator.
And that's right. And that's why the issues are styled that way. Issue one was to dismiss the charges entirely. But if the arbitrator found that he upheld the charges, which he did, the second issue then is triggered, which is, was termination an appropriate penalty for these charges? And the arbitrator determined that they were not. In Eastern Associated Coal, to answer Judge Easterly's question, the Supreme Court held at the end of its decision, we recognize that reasonable people can differ as to whether reinstatement or discharge is a more appropriate remedy here, but both the employer and the union have agreed to entrust this decision to an arbitrator. And that's the case here too.
Well, I guess it might or might not be. And what do you think I should do, or the court should do, not me individually, but if the court concludes actually a 45-day suspension for the circumstances that were factually found here is no reasonable person could think that's an appropriate penalty. Assume that the court were to conclude that. do you think the court is nevertheless powerless because of the limitations in the CMPA about what PERB can do to set aside arbitral awards and the principles of deference that govern how we review PERB decisions? Or do you think that if we ended up concluding that sanction is just not, no one could reasonably think that's an appropriate sanction in these circumstances, that we would have the authority to say, well, PERB, we defer to PERB to a degree, but not to that degree. And, PERB couldn't reasonably have viewed that arbitral award as other than contrary to law or public policy is what the statute says. Do you think we would be powerless, or do you think that we would have authority to grant relief if our conclusion was 45-day suspension? Nobody could think that was reasonable.
I do not believe you could grant relief if your determination was that 45 days was not reasonable. To overturn the decision, it would have to be on one of the grounds presented by the MPD, which is, does it violate an explicit and clear public policy? And so whether or not you agree or disagree with the severity of the penalty imposed, the question is whether it violates an explicit declaration of public policy in the District of Columbia, and it simply does not.
And I'm going to stop you there, Mr. McCartan, and go to Mr. Simpson, who I hope his sound will now work, and we'll give you a couple minutes on rebuttal. I guess we won't give you any time on rebuttal. We'll give some to Ms. Anderson. So let's see if we can bring in Mr. Simpson now.
Thank you. Can you hear me?
We can, yes.
Okay, so my apologies for my technical difficulties earlier, and may it please the court, again, Jeffrey Simpson on behalf of Appellee PERB. Mr. McCartan has ably made many of the same points that I would have made, so I would like to be brief and not to tread on that ground unless necessary.
Do you agree with his answer to the last question, to Judge McLeese's question?
Yes. So the way that the CMPA works and has been interpreted for decades now is that the bases for reversal by PERB of an arbitration award are three limited grounds. And the one at issue here is whether the award is on its face contrary to law and public policy. And so that does not afford the opportunity for PERB to second guess the arbitrator on his factual determinations on the reasonableness of penalties, even when PERB may think, this is not what we would have done if we were faced with these facts, is that the parties bargained for this, and PERB follows the law generated under the National Labor Relations Act, which affords the arbitration awards the greatest deference imaginable, is how one court put it.
Do you agree with Mr. McCartan's answer to another question that I asked, which was, imagine that this case was the same, except that the conduct at issue was like cold-blooded mass murder of other officers and the general public?
So I would say, thankfully, I don't think that the answer would ever be the same, even for the most out-of-touch arbitrators. But I think that the answer is that person would be in jail and wouldn't be able to come back to work in any event if that was what was proven.
Well, those are two ways of avoiding hypothetical.
Yeah. So, but to the height.
Assume for a moment that the person was acquitted, and that the arbitrator and that MPD found by a preponderance, nevertheless, that the conduct was criminal, was in fact murder, and assume that an arbitrator upheld that ruling and said 45 days suspension.
So I would say that the answer here would be the same, that unless there was some law that on its face prohibited the reinstatement under those circumstances, that PERB would not be in a position to set aside that award. Now, if there is a concern about that, the answer would be a legislative fix, because the CMPA has
why it isn't. So if you think of Douglas as kind of a mixed question of law and fact, and maybe discretion, I'm not sure, I haven't really zeroed in on all that. But if you take the facts as given, and if a particular agency in a non-arbitrator context says, we're going to terminate somebody, well, then OEA or some other agencies in the federal system would review that and would make a determination. And if they thought that what the agency was doing was, beyond the realm of a reasonable application of the Douglas factors, wouldn't they be saying, Douglas is the law requires that you reasonably apply it. If you've applied it in a way that is unreasonable, you're acting contrary to law. So why wouldn't a sufficiently egregious application of the Douglas factors by an agency, by an employer in the first instance, or by an arbitrator in the second instance, possibly be contrary to law?
So the answer is that for an agency, that would be a more amenable to reversal than by an arbitrator, because the arbitrator is the product of collective bargaining between the agency and the union. So
I fully understand that.
Yeah.
It seems to be conceptual. So there are additional layers. The policy in favor of arbitration, the word in our statute about on its face. So there are additional layers, I get. But just conceptually, do you agree that a sufficiently unreasonable application of the Douglas factors can be contrary to law?
So just to back out for 1 second, and I promise that I'm going to return to the question, is that the misapplication of Douglas would have to involve two things. That one, that Douglas is the controlling law. And in this case, our parties very often argue that Douglas is the guidelines that should be applied, but it's not the case. And as the arbitrator alluded to, other sources of law, including Al-Khoury and other arbitration, general arbitral principles about what constitutes reasonable cause. So Douglas, the arbitrator did not say, I am required and bound by Douglas and all of its facets and importing all of the MSPB processes that attain to it. He didn't say that. He said, Douglas is the guidepost, the guidelines for review, and they're reasonable guidelines, and they are consistent with other rules. But if the arbitrator said that Douglas is the law, these are the 12 factors, and consistency of the penalty means that two very different situations must be considered the same, or it said something contrary to what Douglas says, rather than a judgment about whether two cases are alike, which is a factual judgment that the parties bargained for.
So I'm sorry to interrupt, but are you saying that the arbitrator could have just disregarded Douglas entirely?
Yes.
Okay, so if you had an arbitral award that was just one page, one sentence, reject MPD panel termination, 45 days.
So that
if
would
that's
be
all it said, is that impenetrable?
So in the unless there would be some reason to forbid the outcome, then there would not be grounds to reverse. So in other contexts,
that seems to be a little unclear. I get that true in general arbitration, but I thought the CBA here required the arbitration to give reasons for like a written statement of decision. So that might have been a special.
Yes. So the answer is that if there is something that was done that was contrary to the CBA, and that that would be an instance where the arbitrator exceeded his authority, and there's other cases.
So the CBA says you have to give some reason.
Yes.
Okay.
But it doesn't.
And if the arbitrator said, I flipped a coin, heads was termination, tails was 45 days. It landed on tails, 45 days is the penalty. And that's in, a one-page arbitral award. Impenetrable from any review?
I believe that in that case that there could be review, that there would be a law and regulations kind of surrounding the bases, so that there has to be a reason given, and that would not be
but he gave a reason. He gave a reason, he flipped a coin. He explained exactly which side of the coin corresponded with which penalty. It was perfectly explained. Everyone understood the reasoning, and it's right there in black and white.
So
Not
this would,
unreviewable. Is
so
that your position?
no, that would not be the position. So the position would be that there would have to be some grounds that are based in, kind of a review of the facts and associated law.
So
That
for
is-
example, to take a slightly different variant, if the arbitrator said, I am reinstating with no penalty because I really don't think employees should ever be disciplined for things they do. I'm a pro-employee kind of person.
So yes, and so that would violate laws concerning grounds for termination and
What
rules.
law?
So
I mean,
it would.
Doug, well, could you be really specific? The CBA doesn't really say anything about that. Some CBAs, I think, are more explicit about kind of a body of sanction law and the like, and what they're relying on, but this one doesn't seem to. And so when you say that would violate a law, what law would it violate? You seem to want a very clear law that has to be violated. So what was the law that violated that hypothetical?
So that would require deeper research than I have in mind, because I hadn't thought of that. I would expect, for example, in the district personnel manual, that there are grounds for termination under, 6B 1600 at SEC, that termination is for just cause, and that those sorts of rules. But what we have
Perhaps
here
it would violate something that required the arbitrator not to fraudulently take on the arbitration job by representing that he will be impartial and not always favor one side over the other.
So there are the other grounds, and Judge Thompson, that point is well taken, that there's instances where an arbitrator can exceed his authority, and if the authority granted to him is to review the decision, and if he doesn't do that, if he does not undertake any analysis as these hypotheticals posit, then that would be an instance where he is not answering the question whether termination is appropriate. He is just deciding based on random chance or on flip of the coin, or just always taking the same position. And so he wouldn't be answering the question posed to him. He would just be exercising his own brand of industrial justice, which is grounds for reversal. And so, but that is not what happened in this case, where he looked at the factors, and even if one is dissatisfied with the analysis, the dissatisfaction with the analysis is not grounds to set aside the award, under how PERB has interpreted the CMPA and how federal arbitrators under the NLRA have interpreted awards for decades.
Could you be more concrete with respect to the following body of PERB decisions, which this court has endorsed, which is the idea that one circumstance in which PERB can step in is if an arbitrator identifies an external source of law and purports to apply it, but then ignores or overlooks it. I'm maybe paraphrasing there, but your opponent argues that that is a body of law under which PERB, by its own terms, ought to have intervened here, and that PERB didn't really adequately explain why it wasn't willing to do so in this case. What's your response to that?
So that body of law, that line of thinking, it stems from an FOP versus PERB case, where the arbitrator purportedly applied the Back Pay Act for the source of his authority to award back pay, then awarded back pay without offset for interim earnings, which expressly contravened the statement in the Back Pay Act about what you're supposed to do. So you have an express provision of law that says X, and then the arbitrator did the exact opposite. So by contrast here, you have the arbitrator reviewing factors that may be helpful in determining whether termination is the appropriate penalty, and then looking to see the consistency of the penalty factor, and he sees it, he identified that as important in general arbitration law generally, and then in the Douglas factors, looked at other cases, and particularly the Ford case, and made his own factual determination that case is persuasive and that the consistent penalty would be a 45-day suspension. And so he is not looking at the consistency of the penalty factor and saying, and doing the opposite of it. You can question and challenge his application of the consistency of the penalty factor. And, others can obviously disagree with the outcome, but he is doing what he was asked to do, and and that his application of it doesn't on its face contradict what Douglas says, which is that these are, fact-intensive inquiries, and PERB is required to accept the facts as determined by the arbitrator.
Can I ask you, I asked you a question and you said you would get back around to it, and then you haven't yet. And I know you got pulled away, so that's not a criticism really, but just to try to wrap back around and give you an opportunity to address it. I'll try to frame it more simply this time. Leaving aside arbitration, if Douglas governs the decision about whether to discipline somebody or not, and if so, what sanction to impose, and if somebody who's obliged to follow Douglas applies those factors in a way that nobody could think was reasonable, is that contrary to law?
I would say that the answer would be, it would have to be very specific, and that the answer would be no, that it wouldn't be contrary to Douglas if there was an effort made to comply with it.
So then what are courts doing? Like, what's the Federal Circuit or the doing when they overturn agency determinations in that area? They're not, you don't think they're doing law. That's not they're not correcting legal errors. They're doing something else.
So that is an entirely different body of law that does not involve arbitration awards, where there's the same deference effects. And so that,
my question does involve arbitration. I'm asking you an abstract question, which is,
so they apply, and just like this court in summary judgment, somebody comes with a set of facts about any given case, and the court determines that no reasonable jury can determine X, that no reasonable jury can determine that there was a breach of contract or what have you, and that's the standard that you would apply in summary judgment.
And that's the question of law, right?
Yeah.
You agree?
And that is a question of law, but there is no reasonable arbitrator standard that applies.
You keep wrapping in arbitration, but my question isn't about arbitration. I'm just trying to figure out whether abstractly it is contrary to law if a decision maker misapplies the Douglas factors when the decision maker is bound by them. I know you don't think arbitrators are bound by them, and that arbitration affects other questions, but I'm just trying to figure out whether you think if somebody who gets the Douglas factors wrong when they're, it's to the point where no reasonable person could have done it that way and reached the outcome that was reached, whether that is a mistake of law that courts are correcting as a matter of law when they do correct it, or whether it's something else. And it seems to me it is law. And I thought your answer was it's not law. And it's not contrary to law to misapply Douglas when it's binding so badly that no reasonable person could accept that. And that seems to me counterintuitive. That seems to me like it is contrary to law if you do that.
So I want to make sure that I understand the hypothetical and just try and have the principles kind of in place so that
I'll try to make it really simple. So imagine that the way a system is set up is that employers can a public employer makes a termination decision, and that is governed, and the employer is required to follow Douglas. That's its body of law about what sanctions are appropriate, which has process and lots of things. And that the decision of the agency is reviewable in court. And imagine that a judge who's reviewing that agency's determination says the agency's determination and application of Douglas factors is not just not what I would do, but it's so wrong that no reasonable person could do it. If that's what the court concludes, and the court says, is that a conclusion that the employer's decision was contrary to law? Conceptually, is that saying that's contrary to law?
I don't think that it is. I think that it is an instance where that there is a severe factual error that was made if the application of the Douglas factors was such that nobody could believe, for example, if the comparison was the other case, like kind of just to bring your mass murder in the police station example, if the arbitrator compared that to jaywalking and said, well, you didn't fire him for jaywalking, so I'm not going to fire him for mass murder, that would be an outcome no reasonable person could agree with, but it would be a decision that was made on a factual basis.
Yeah, I don't actually see that as a question of fact myself intuitively. Now, maybe you're right, but off the top of my head, I would say to try to figure out whether one circumstance is similar to another as it relates to what sanction is appropriate is definitely not a question of pure historical fact. It's got legal components to it, maybe sometimes to be a mixed question, I don't know, but I don't see it as a question of fact. But you're over your time, and I don't mean to belabor this. So
I was going to observe that this is not an APA case, but I was thinking about the phrase in the Administrative Procedure Act, arbitrary, capricious, or otherwise contrary to law, seeming to suggest that arbitrary and capricious is contrary to law. I did want to ask you one question before we end, Mr. Simpson, and you may have addressed this today or in your brief, but I just want to focus my understanding on this point. What is your response to MPD's argument that one problem here, maybe the biggest problem here with the arbitrator's decision, is that he purported to apply the Douglas factors himself, but then he failed to do the weighing that was required? What's your answer to that point?
So the answer is that that arbitration awards are not subject to beady-eyed scrutiny. That you do not look at the arbitration award in such a way that you try and find flaws that would allow you to overturn. You look at the arbitration award and see if there's any permissible route to uphold the arbitration award. And so the lack of weighing, the weighing is implied in the outcome. So the arbitrator reviewed all of the Douglas factors, pointed out where the flaws were, and then made a determination on the outcome. So the weighing is implicit in the outcome that the arbitrator states.
Would you agree that if he failed to weigh, that's a problem? Was that something that PERB could have stepped in to address?
So if there was a statement by the arbitrator saying that I am not going to weigh the factors, and that versus just the implicit weighing that was done here, then that could lead to a possibility. If he said, I'm relying on Douglas requires weighing, I'm not going to weigh the factors, and I'm just going to have this outcome, that could be a circumstance where PERB could intervene, but that's not what happened here.
I know we're over time, but I did mean to ask you one question about deference to PERB and how much deference this court owes to PERB, because although I found the cases on that unclear, and I found the briefs a little bit unclear at times. I think your opponent has said that she agrees that we should give kind of ordinary deference we give to expert agencies on the question of kind of PERB's authority to set aside arbitral awards. At times, your brief seemed to suggest that PERB is entitled to ultra deference that's stronger than that kind of deference. Are you arguing for higher deference than other agencies typically get in settings like this, or are you in agreement with your opponent on that point?
We agree that the deference owed is the same and is based on PERB status as an expert agency, just like other agencies are experts in their line. With the observation is that the way that this court has described that deference in the case of PERB that PERB's decision must be rationally indefensible for
But
the
if
court
you
to.
think that's the same as any other formulation, I gather you have no problem with general formulation that seem would follow from what you just said, but.
That is correct.
All right. Thank you, Mr. Simpson. And let's go to Ms. Anderson now, and we'll give you a couple minutes for rebuttal.
Thank you, Your Honors. The first point I'd like to address is the question of whether or not there can be implicit findings in this arbitration award. And it's MPD's position that the findings cannot be implicit. They must be explicit because the collective bargaining agreement requires a written opinion from the arbitrator explaining his decision. So it's not enough to simply try to infer in this case that the arbitrator did the proper weighing. It's evident from the face of his opinion that he did not engage in weighing. And it's our position he was required to do so, not simply because this is an arbitration. In all arbitrations, arbitrators are required to do this. It's because FOP explicitly requested that MPD's decision be judged by Douglas. And the arbitrator seemed to agree, clearly focusing on Douglas throughout his analysis. But what he failed to do was properly weigh the factors before overturning the decision. And with respect to Ford as a comparator, I would just note the only thing in the record that we have about his case is the notice of proposed adverse action. We have no indication in the record as to what MPD actually found him guilty of before imposing that 45-day sentence. So saying that Ford is a comparator is just as arbitrary as pulling a penalty out of a hat or flipping a coin. There is no basis to find him comparable, but that is the only basis the record reflects that the arbitrator relied on for imposing a 45-day suspension in this case. And that 45-day suspension is not only contrary to what Douglas requires, but it's contrary to public policy. Ask that the court overturn and vacate the arbitration award in this case. Thank you.
Thank you, Ms. Anderson. Thank you to all counsel. I'm glad we got your sound problems resolved, Mr. Simpson. You recovered well. We appreciate your arguments. The case is submitted and counsel may exit our remote courtroom. Thank you.
Thank you.
Thank you.
And let me call our third matter, which is number 20 BG 0601 in Ray, Denny Antoinette Mazingo Mayron. It's a Board on Professional Responsibility, docket numbers 14 BD 60 and 15 BD 014. Let's see if I see both counsel. I do. And with that, we can proceed.
Good morning, Judge.
Good morning. Good morning. Are we starting with you, Mr. Link?
Your Honor, I think we're starting with Mr. Iwinoge, who is took the exceptions in this case.
He did indeed. Yes, Mr. Iwinoge,
Yes, Judge.
you may proceed.
Thank you, Judge. On behalf of Ms. Denny Mazingo, we'll be asking the court not to find the violations resulted in a deferment requested by the Office of Disciplinary Counsel, and that was given in this case by the Board on Professional Responsibility. A little bit about the history about this case. I know that the court has looked at the case, read the briefs of the parties, but I believe on the 27th of January, when the briefs were filed, for the record, one was filed erroneously at 11:15 p.m. and then subsequently a notation with another filing at 11:52 p.m. I want to make sure that the court is aware of the brief that was filed at 11:52 p.m. is the actual brief for the respondent in this case.
I'm not sure that what I have accessible to me right now shows the time of filing, but that's certainly something we can check on.
Yes, Judge. Okay. The history about this case, Your Honor, is this case with the specification of charges was filed by the Office of Disciplinary Counsel in July 2014. The alleged incidents involving Ms. Mazingo date back to 2005. The hearing committee, after almost about 5 years, issued its recommendations June of 2015. Fast forward 5 years later, or actually the hearing was June 2015, and which was about a year after the actual specification of charges were filed. Almost 5 years later, I'll say 4 years and some change, in October of 2019, the hearing committee issued their report and recommendation. Subsequently, there was a recommendation made by the hearing committee that listened to the testimony, observed witnesses, made credibility findings, and wrote a proposed findings of fact and conclusions of law. No party, not the respondents, not the Office of Disciplinary Counsel in this case, took exceptions to those findings of fact and conclusions of law. Subsequently, there was an oral argument before the board on professional responsibility. Exceptions were taken with respect to the sanctions by the Office of Disciplinary Counsel. There was an argument before the board. A decision was issued in 2020. Part of that decision was reversing or overturning the finding issued by the Board on Professional Responsibility, by the hearing committee as it relates to the sanctions in this case. The sanctions by the hearing committee, at least their recommendation, was a suspension of 6 months. They did go through all the factors, all the facts in a lengthy report over 120 pages, elucidating the reasons in support of the decision that they rendered after about 4 years. In looking at the case from respondents' point of view, and looking at the factors laid out in PIC, the seriousness of the misconduct, the hearing committee found that the actions in this case of my client, though there were some dishonesty found, but then they found that the case was somewhat serious. In addition to finding that the case was somewhat serious, the analysis went into why they believe it was inconsequential. I'll go through some of it, bearing in mind that I don't have all day to talk to your honors because you've looked at this case, reviewed the filings in this case.
Well, we have, and I think it would be helpful if you would focus for us on why, in your view, the board's recommended sanction falls outside the range of sanctions that we have imposed for conduct like that involved here. There is, I think we could all agree, a broad range of sanctions that this court has imposed for violations of the rules of professional conduct involving dishonesty, for example, persistent dishonesty, ranging from something even less than 6 months to a few years suspension up to disbarment. Why in this case should we reject the board's recommended sanction as falling outside that range? Because as you know, generally speaking, we defer to the board's recommended sanction, departing from it only if we find that, for example, it is outside the range of acceptable sanctions.
In this particular case, what happened, or the way I look at it, is there was no pattern of dishonesty found by the hearing committee. No party took exceptions to it, but then most importantly, there was no flagrant dishonesty found by the hearing committee. In looking at the report and recommendation on professional responsibility, I don't even see where there's a finding made by the board on professional responsibility as to finding of a flagrant dishonesty. The only thing that I could see is where the board discusses dishonesty that was in this case, but then goes on to jump into I believe that appears in the report and recommendation of the board, where it jumps into the flagrant dishonesty dealing with the cases of Anya. But then in the Anya case, there's a blatant practice of continually lying to the court. But then this was over a protracted period. This is not the Danny Manzingo case. And then the board then discusses the Kano case, where you have an individual that lied on visa application submitted on behalf of a client to tribunal. But then in addition to that, made promises to repay funds owed to a client, not only to the disciplinary council, but also to the client, but that was never repaid. They then cite the Onwenga case. In that case also, that includes Mr. Onwenga filing false documents, making misrepresentations to a court. But then in addition to the fact that misappropriation was found in that case, the three cases relied on by the board doesn't fit the facts of this case. What we have is Ms. Manzingo, one, filing bankruptcy petition on behalf of herself, but then finding of dishonesty. But then you have an 8.4C violation, but then not an 8.4B violation, as was discussed by this court in the Pelkey case. So that distinguishes this case from the Anya case, the Kano case, and then the Pelkey case, where the court discusses what they talk about in a finding of flagrant dishonesty. We don't have it here.
Can I ask you about the finding? I thought the board did find flagrant dishonesty here. And I'm focused on page 24 of the board's report and recommendation, where the text says respondent's conduct is comparable to that of others who've been disbarred for flagrant dishonesty. I recognize that sentence by itself only implies that. But then if you go to the footnote down on page footnote 3, it says, we note our determination that disbarment based on flagrant dishonesty is warranted in this manner. And so I thought the board did find flagrant dishonesty in this case. Can you, I guess, address that?
Yes, Judge McLean, the way I read it, it says, it's like, it starts out at the top on page 24, respondent's conduct is comparable to that of others who have been disbarred for flagrant dishonesty. Then cites the cases that I've discussed, but then it goes in the footnote to then say that this is comparable to the case where they found flagrant dishonesty in the Anita Johnson.
I don't think that's what the footnote says. The first sentence of the footnote says, we note our determination that disbarment based on flagrant dishonesty is warranted in this matter. That to say that, you know, we're disbarring here based on flagrant dishonesty seems to me, I mean, it's worded in sort of a passive voice kind of way, so it's a little convoluted, but it seems to me logically that's saying we are concluding flagrant dishonesty and we're saying that it warrants disbarment, both in this case. So I saw it as a finding, but.
The only problem with that case, that this is a case, the Anita Johnson case, is not even, has not been up before the Court of Appeals. No decision has been made on that case. That case is still pending before the court because they said that they make or reach that decision based on another case that they find today. But then it doesn't go through the factors that this court elucidated when one finds flagrant dishonesty. There's no 8.4B violation.
Right, but this is responsive to your argument that the board didn't make a finding of flagrant dishonesty, and that the board seems to be doing just that in the footnote, where it's talking about the Johnson case, which involved repeated, persistent, and pervasive dishonesty, which echoes the language back on page 15 of the report, right? Where the board is going through the seriousness of the conduct at issue, right? And says the respondent's conduct was undeniably serious. Most troubling, the record catalogs respondent's persistent difficulty in telling the truth for almost 4 years after her admission to the DC bar and after she'd been admitted to practice as an attorney in the U.S. District Court for the District of Maryland. She represented she was a non-attorney filer on bankruptcy petitions. When she sought admission to the U.S. District Court of Maryland, she intentionally failed to disclose her misdemeanor criminal convictions. In her own bankruptcy filing, she failed to disclose information regarding her assets and payments to creditors, despite her extensive experience preparing bankruptcy filings. Right. And then it goes on to talk about her penchant for deceit. That's their language. When she said that was on display when she represented Ms. Simmons in her negotiation with the Geico matter, where she, didn't disclose that she wasn't admitted to practice in Maryland, and really engaged in some quite questionable conduct. I mean, very troubling conduct. And in the end, when she ends up emailing Geico, CCing Geico on an attorney-client communication to the detriment of her client, seemingly to, get her client to pay her money. So, in addition to the dishonesty, I think that there's this sort of sharp dealing that the board thought was very, very serious.
Judge Easterly, I'll say that these are the same findings that were made by the hearing committee, but then the analysis engaged in by the hearing committee that comports with the cases that appeared before this court and decided by this Court of Appeals is one, how did this affect or prejudice the clients? How did it prejudice the court system?
Well, in the Geico matter, I think it very clearly prejudiced the client, right? To have her communications about settlement discussions with her attorney revealed to the insurance company. I mean, that's pretty serious in my view.
Actually, Judge Easterly, I agree that was, I'll say it was a mistake on my part. I think what was lost in translation in terms of what actually happened, where the dishonesty was found in the Geico matter is when you're sending something to an individual and then you're copying your client, in this case, putting a lien on the case. Unfortunately, some communication tracked or was joined as part of it. I am not quibbling with the facts because the facts are what they are. But if I draw your Honor's attention to the finding on page 18, subparagraph 2, prejudice to the client, not only did this not affect Geico's decision in this case, but then most importantly, the offer did actually increase from what it was when she was the attorney of record and then subsequent communication. So it did not affect or prejudice the client because the offer actually increased. And this was a finding that was actually—
I'm not sure how logical that chain of reasoning is. If there are negotiations ongoing and my lawyer tells some stuff to the other side that doesn't help me, I don't know that the fact that the number improved a little bit from there doesn't mean that it wouldn't have been better if the number might have increased more. I mean, it's speculative, but I don't know that it's logically obvious that just because the number increased after that disclosure, the disclosure had no effect on what the ultimate number was. Yeah. Can I ask you, as Judge Thompson's question suggests, you have kind of an uphill battle here on sanction because we defer to the board unless showing can be made about this would be kind of out of sync with sanction other cases or is unreasonable. So on the question of out of sync with other cases, if you were going to pick a case that you say we should go look at it, and when we see the sanction there, which was short of disbarment, we'll realize that it's quite comparable conduct and that it really would be out of sync for conduct like that to be sanctioned by disbarment. I know at the end of your brief, I think on page 42, you list like 5 or 6 of them. Some of them seem more or less close. So I'm just curious which one or 1 or 2 you think are the best examples of why disbarment here is just out of sync with what the board has done, or what this court has done, what the board has recommended or this court has done in cases that you think are comparable.
Yes, Judge McLeese. The one that comes to mind is the Shoneman case, where there was a misrepresentation or kind of false statement, where there were documents and information that were not true, and then unauthorized practice. So that is the first one that jumps to mind in terms of this case. But then most importantly, Judge McLeese, I will also fall back on another case, which is the Ponce case that deals with disclosure based on the question and the prejudice raised by Judge Easterly in the question as well. But the Shoneman case where there was a suspension, the analysis done by the hearing committee is on point. A good example in support of the reason I submit that this ban not even the should be the recommended sanction in this case is in terms of mitigation. The board says that there was no finding of inexperience. This appears on page 21 of their report. There was no finding of inexperience by Ms. Manzingo, and as such, they believe that the sanction of dismemberment should issue. It's echoed in the footnote that appears on page 21. However, on page 123 of the hearing committee's report and recommendation, they clearly talk about her inexperience as part of the reason that we're making the recommendation. But then most importantly, I asked this court to also consider the fact that the violations in this case happened in 2005. And then the Ezukama matter was 2005 to 2007. The isolated matter in 2010 was the Simmons matter. She's not practiced law. I mean, these cases have been about 18 years old. Question is, what is the size that should be meted out to protect the public? And then in case of future misconduct, there's nothing in this record that they say there's been any future misconduct by the respondent, Ms. Manzingo, in this case. But then most importantly, as we have this discussion about what to do, I understand and do not quibble with the facts on behalf of the respondent. Neither party did. But then as we continue to look at the law, which is evolving, part of it is what we call it the practice of law. It's a new case that I was looking at because in doing doing cases involving representing attorneys, I do read cases that come from other jurisdictions. Quite recently, in a case from the Maryland Court of Appeals, in the Jackson case that came out on June the 31st, the court, in dismissing the petition of AGC in that matter, also raised issues where, in this day and age of Zoom, where portability is the watchword for the practice of law, individuals practice law from anywhere. I could be a member of the District of Columbia by, in this case, sitting at home if I live in Philadelphia and be doing this oral argument by Zoom. Judge Berry, in the opinion that came out on the 31st of January of 2021, was inviting the Committee on Judiciary and Standards to review the rules as it pertains to 5.5 with respect to unauthorized practice of law to see how that fits with a portable profession, which is the practice of law. You translate that additionally to the case before this court. We understand that she practiced from Maryland. We understand Geico and her client relied on it. But then the question is, how do we punish that conduct? Additionally, and most importantly, there's a discussion on the board professional responsibility, finance of facts, and conclusions of law that because Ms. Manzingo lived in Maryland or the client lived in Maryland, the case was going to be ultimately litigated in Maryland. I will submit that that is not 100% correct. A plaintiff's lawyer could choose to sue the defendant where the defendant resides. It doesn't necessarily have to be where the plaintiff resides. There are a lot of.
I guess I'm thrown a little bit for a loop on this. Is this set of arguments about unauthorized practice of law and challenging either whether there was a violation or, you know, what remote practice has to do with that? None of that was in any of your briefing. Is that right? I just don't remember any of it.
No, Judge McLeese. I was just saying that this came out. This decision now was January the 31st, and it's not in my brief. It's not in my. It's not in my brief, and the issue was not ripe, or the issue did not come up. But in preparing for this argument, those issues started coming to me in terms of what to bring to the court's attention in terms of what an appropriate sanction would be in this case. But Judge McLean, if you look at all the cases that we cited, and thus the hearing committee found, even these violations standing alone, or even in combination, looking at the factors laid out by this court as it deals in the Guberman case dealing with flagrant dishonesty, there was nothing in this case whereby the dishonesty was used to conceal another dishonesty. Judge McLeese, this woman applied to the bar of the District of Columbia, was approved, revealing the fact that she had prior misdemeanor traffic violations in her past. The failure to disclose it in Maryland, while it may not be believed, however, her explanation was found to be dishonest. Yes, but then the question is, if she had revealed that information, would it have affected, as the hearing committee found, her application? Unlike the Anya case, unlike the Kano case, unlike the Owenga case, it affected their lies, their deceit, affected our judicial system. In this case, it did not. She would have still ended up being a member of the bar of the District Court of Maryland, because she was.
One thing I want to ask you, counsel, before you sit down is this. You began your remarks by pointing out that this case was unlike another that you mentioned, because there, in that other case, I forget which one it was, there had been a promise to repay funds taken from the client or owed to the client, and that never occurred, and you were distinguishing that from the situation here. That reminded me of the facts surrounding the revenues from the monies from the sale of the house in that bankruptcy matter in which your client represented an individual. And the board considered whether there was a violation of Maryland Rule 1.15 having to do with funds that have been entrusted and protecting the funds of the client, and concluded that there was no entrustment because your client didn't know that creditors had not yet been paid from the sales proceeds, and didn't know that the money belonged to the bankruptcy estate and not to her. Here's what I want to ask you. Have you looked at our recent case, a 2020 case in Ray Harris Lindsay, where the court addressed what it means for funds to be entrusted? One of the things that the majority said in that case was that funds are entrusted to a lawyer, and this was actually in connection with funds that were in a joint bank account where the lawyer did not have exclusive control. But the language I'm interested in is the language that says there's entrustment if the lawyer is vested with sufficient authority to prevent improper dispersal of the funds. Now, in this case, your client testified that she thought that the title company would pay the creditors first, but she didn't confirm that before she took the money and spent it. Is this an instance where she was vested with authority to prevent improper dispersal of the funds, such that we should reject the conclusion that there was no entrustment and no misappropriation? Have you thought about that?
Yes, I have, Judge Thompson, and this is not such a case. This is a case, having been involved in this case for so many years, Judge, including litigation in the bankruptcy court. The bankruptcy court held a hearing in this case and made its own findings. They didn't find contempt of court for doing the practice by not saying that she's a non-lawyer. She was fined $4,500, which she paid to the court. In terms of the violation for the disbursement of the fund, an agreement was reached to the amount, and she started paying it to the trustee, and there's nothing been filed that the money has not either fully been paid or
There's
she's not.
nothing in the record that shows she paid it, but you're representing that she has paid it?
To the best of my knowledge, Judge, she was paying it to Mr. Orenstein, and the transcript appears on page. I remember asking that question. I believe it should be page 328. My understanding from the testimony at the hearing is that she was making monthly payments, and I believe that should be transcript page 328. And then in terms of the payment of the $4,500, that appears in the report, I believe that page 43, paragraph 96. But it's my understanding that the payment was, when I asked that question at the hearing, it was pursuant to a payment arrangement that it was making monthly payments.
That was a different matter. That was the fine for practicing in the bankruptcy court without authority, wasn't it?
There are two of them, two payments, Judge. One, the 13,000 was based on a case was filed, and we reached an agreement with the trustee, and there was a payment arrangement set up, and she was making that monthly payment to the trustee for the 13,000. That's one. And then the record I have is from the hearing, according to Mr. Orenstein, who was receiving the money, she was making the monthly payments. Whether it's fully paid to date, I will suppose it has, because I didn't receive anything from Mr. Orenstein advising me that my client has not paid. So I have no reason to believe that it's not been paid. But have I verified it? No, because I didn't receive anything that it was not paid. As to the
whether or not this 13,000 and change was paid in connection with the sales proceeds, is that a matter more serious than the hearing committee and the board regarded it to be? Because it involved some responsibility to prevent the improper dispersal of funds?
Unlike the case that Yona was talking about, she did not have the authority to prevent the dispersal. As I understand it, Judge Thompson, she attended a settlement. You know, it wasn't within her powers whether to do it or not do it. The sale was going to happen regardless because it was authorized by the court. The disbursement was handled by the settlement company. She had no control and could not stop or prevent it from happening. So unlike the case where quite alluded that the person has the authority to stop the sale, in this case, I submit that I do not believe that it is analogous to this case where she had the authority to stop a sale that was court ordered to be done, and then the disbursement of the funds. So she could not stop it, as I understand it, from at least from what the trustee testified to and everything that happened, because there were other people that received monies from the table, Judge. She was just there and received money like everybody else. She wasn't the only person that received money on that day. There was seller, buyer, another attorney, and then other things that were paid. So she had no control and could stop it, but then refused to stop it, Judge.
All right, thank you, Mr. Uenogi. Your time is expired. We'll give you a couple of minutes on rebuttal, and let's hear from Mr. Link.
Thank you, Your Honor. I think my learned friend has made the argument that can be made for respondent in this case. Unfortunately, it is simply insufficient. The board unanimously recommended a sanction of disbarment, and we urge the court to adopt the board's recommendation. The board did find flagrant dishonesty, and this court has defined flagrant dishonesty in a number of ways. The one most relevant to this case is the court's definition in In Re Corrisi, where the court said flagrant dishonesty reflects a continuing and pervasive indifference to the obligations of honesty in the judicial system. That's exactly what we have here. Contrary to respondent's argument, this dishonesty took place over a period of 8 years. Disciplinary counsel and the board did not look at each individual incident as isolated, and we asked the court to consider these incidents. As Judge Easterly pointed out, we have respondent lying under oath in our application for admission to the U.S. District Court for the District of Maryland. And note that the defense there is that, well, had we told the truth, the court would have admitted her anyway. The idea that we're going to say someone can, an attorney no less, can decide when and when not to tell the truth to a court because the attorney will decide what is important to the court is simply not credible and not acceptable. She lied in the
Mr.
plea.
Link, let me ask you this question. In the board's report, and let me find the page. I think it's at page 21. The board quotes this language from In re Pennington, where this court referred to flagrant dishonesty as reflecting a continuing and pervasive indifference to the obligations of honesty in the judicial system. And the board, what the board says is that this court has held that disbarment is the appropriate sanction in that instance. Well, Pennington itself is not a disbarment case. I think it was a case involving a 2-year, maybe 3-year suspension. And what the court said in Pennington was about cases such as Carisi and another case where what the court had before it was the manufacturing of evidence by the respondent in that case. Or another case where what was before the court was suborning of perjury. And that's what the court was focusing on when it said disbarment is the appropriate remedy. As I look down the list of the instances of dishonesty by this respondent, Ms. Mazingo, it seems to me that one might say they are somewhat different. I'm interested in your reaction to this because what occurred to me is that in most of the instances, perhaps not all of them, but in most of the instances, what you have are what you might call sharp practices, kind of pushing the envelope further than most people would. For example, there's the instance where on her bankruptcy petition, Ms. Mazingo is asked whether she's made any payments in the last 90 days of more than $600. And the facts are that her husband made the mortgage payment and it was $1,200. And her answer is no. And her explanation was, well, he made it, she didn't. And you can see that that's not an answer that we lawyers ought to give, but you can also see that in some sense of the word, it is true in the sense that she didn't make the payment. Or what else? She files papers in the bankruptcy court and she certifies that she was a non-attorney filer, even though she had been admitted to the bar in the District of Columbia, and even after she had been admitted to practice in the District of Maryland. And you might say, well, because she wasn't licensed to practice law in Maryland, there was a sense in which she was not a Maryland lawyer, i.e. a non-attorney filer. So you can see that there's a way in which this is true. It's a sharp answer. It's not disclosing all that there is. I just named those examples. There are a few others you could name. And I just wanted to say that it seems to me someone could say that though she was dishonest and though there are multiple instances of it, it is more like sharp practices and it is not so much like suborning perjury by witness or manufacturing evidence in a court. What's your reaction to that? Because I'm really focused here on where in the range of penalties does her conduct fall. There are so many of these cases involving penalties of suspensions of 2 or 3 years as opposed to disbarment. As you know, there are even cases involving 6 months or fewer months. How do you respond to what I've just described?
Thank you, Your Honor. This court has also said, quote, lawyers have a greater duty than the ordinary citizen to be scrupulously honest at all times, for honesty is basic to the practice of law. And it's when you look at the range of her dishonest conduct that you see she has a pervasive indifference to the obligation of honesty to the judicial system, which makes disbarment appropriate. For example, if the only instance here of her dishonesty was her application on the schedules and forms she filed in connection with her own personal bankruptcy case, we probably wouldn't be here. What makes that significant is it is one instance, it is one example of a multiplicity of cases. She represented over 55 litigants in the bankruptcy court, falsely stating that she was not an attorney in that court. The point about today lawyers can be located in many different locations and represent clients elsewhere is completely irrelevant, because wherever you're located, you need to disclose to your clients what bar you are admitted to practice in. If you practice from a house that you live in Maryland and don't disclose to your clients and potential clients that you're not admitted in Maryland, they will logically think you are admitted in Maryland because you're there. Her dishonesty when she communicated confidential attorney-client information to the party she was negotiating with, essentially her adversary in terms of this negotiation on behalf of her client, that violates the duty of confidentiality, which is one of the most essential elements of the attorney-client relationship.
Well, that is certainly for sure. I wanted to ask you about that in particular. The board, perhaps the hearing committee, drew an inference that Ms. Mozingo revealed some of the information, such as the fact that her client had terminated her to Geico for her own advantage. And I was puzzling a little bit over how that was to her advantage. Do you understand that inference?
At that point in her relationship with her client, she was angry at her client because of their dispute over the fee agreement and over the language in the fee agreement and what the client had to pay. This was essentially her getting back at her client and sort of trying to, because remember, by the time she disclosed it, she disclosed she was no longer representing her client. So therefore, she felt free to sabotage the
I thought it wasn't just, counsel, I thought it wasn't just retributive. I thought it was, she was trying to use this as a lever, right? Didn't she tell them not to communicate with her client about settling or negotiating unless and until she got paid?
That's exactly right. And in fact, every instance in which she committed dishonesty, which is reflected in the record, in every instance, it was to benefit herself. It was knowing, and that's the hearing committee and the board both found knowing, intentional actions intended to benefit herself.
Well, the hearing
And a
committee
multiplicity
found,
of actions.
right, they definitely rejected her explanation that she hit, a button by mistake. No, they said she typed in the name of Geico's counsel. They made that finding. And then they made this finding about how she disclosed the fact that her client was paying her only $250 in fees and had terminated her for her own advantage. That's the one that I don't understand. How was it to her advantage to disclose that the client had terminated her? Now, the damaging part was that she also had attached to the string of emails the various correspondence with the client, including the correspondence in which she said she didn't want to take this matter to trial. And yes, it's quite easy to see how that undermines the client. But there are no specific findings about how that occurred. And it occurred to me, and I'm not trying to substitute for the hearing committee's findings. My point is that they didn't make a specific finding. I have certainly seen it to be the case that people forward emails, they forward the part they mean to forward, but they also have in it a string of other things which they didn't really mean to send. Much of the time it doesn't matter one way or the other, but they just didn't delete the things they did not really intend to send. And there's nothing in the record about whether that occurred with all these attachments. The hearing committee didn't really make a finding about that. They simply made a finding rejecting her statement that she sent an email to Geico by accident, by just hitting a reply button. So I'm left with the sense that somewhat more is read into that than perhaps is fair, because no findings were made on it. What's your response to that?
Thank you, Your Honor. The hearing committee specifically found that she lied when she said it was a mistake and she sent it by mistake, that in fact it was intentional. And with respect, Your Honor, I think that's the key. She intended to send. We can speculate about her motives. I would suggest that a violation of 1.6, if it's clear on its face, it's clear on its face. This violation is clear on its face, and speculation about her motives is not necessary. She violated her client's confidential information when she transmitted it knowingly and intentionally to the Geico examiner. And let's
I guess
not
the
forget-
it is what I'm asking about. What is it that the board found or the hearing committee found she transmitted intentionally? Certainly the termination letter, because that was the
And-
focus of their
right.
discussion. It's
And-
not
and the
clear to me that they found the rest of it, the rest of the transmission was intentional in the sense that she meant for those documents to go. There's no doubt they found that she hit the button on purpose when she hit forward or whatever she hit.
Your Honor, with respect, I think it's clear that they did find that she intended to send everything that she sent. And let's not forget, the argument that somehow this didn't disadvantage her client is completely bogus, to be totally candid. What her client had to do, terminate this, she had terminated Ms. Mazinga. She then had to retain a separate counsel. Ms. Mazinga had put a lien on the client's property. Her new counsel had to get Ms. Mazinga to release the lien. She only released the lien after she was contacted by her former client's new counsel. And then her new counsel had to negotiate a settlement with the Geico representative. So the fact that the client was able to engage in self-help remedies, the fact that the client was able to engage new counsel, the capability of the client cannot excuse the culpability of the lawyer. The lawyer was culpable in her conduct, and of all of the multiple instances of her disingenuous conduct in this case, the violation of 1.6 is probably the most egregious. It was fortuitous that the client in this case was not harmed further. And we cannot somehow say that in mitigation, clients were not harmed, because nothing the lawyer did, nothing the respondent did was intended to in any way minimize the harm caused her misstatements and lies caused the clients.
Counsel,
Back to the definition.
Counsel, it'd be helpful to me if we focus a lot on your sense of the conduct at issue, but in a way, the other half of the equation is to keeping in mind the deference we give to the board. Is a sanction here, given that conduct of disbarment, within the realm of typical sanctions for comparable conduct, or is it outside it? And it would help me two parts of this. Your opponent cited a bunch of cases, about 6 or so on page 42 of his brief. And he has an argument, emphasized the Schoenemann case as one he claims is factually comparable. And I'm interested in your explanation of why you think the cases that he's relying on are not comparable. And relatedly, if you were going to point us to some case that you think is most like this, where a sanction of disbarment has been imposed, that would be helpful too.
Thank you, Your Honor. I think the cases that a respondent relies on are not comparable because they don't involve the multiplicity of violations we have here across a range of different rules, violating not only obligations to the client, such as 1.6, but obligations of candor to the tribunal, such as the violations of Rule 3.3. So, and they take place over a number of years, 8 years, the board found, and they involve multiple violations involving multiple rules that have been violated both in Maryland and the District of Columbia.
Well, I mean, the Schoenemann case, it was largely a neglect case, but it had some honesty components to it because there were false statements made to the clients about the status of the cases. And that involved multiple clients and spanned a couple of years. And so it does seem somewhat more extended. So it's not really isolated. And that was a suspension case. So your distinctions are, I guess, somewhat greater number of incidents. And then also, I think it's true that, at least as far as you can tell, in Schoenemann, there weren't false statements made to tribunals, it was just to clients? Is that,
Right.
are those the principal distinctions, or are there others I'm missing?
No, those are the principal distinctions. I'd also note, although it's not necessarily a distinction that's relevant to Shutterman, it's a fact in this case alluded to by Respondents Counsel regarding the payment that she was ordered to pay in the bankruptcy proceeding when she took money that in the distribution, and she took it as her attorney fees. She was not obligated to take that money, and having taken it, if she was going to do it, she could have put it in a trust account, which she did not do until it was determined that in fact she was permitted to take that money as attorney's fees. She did not do that. And again, she was not obligated. No one forced her to take the money. Obviously, she wanted to be paid her what she thought she should be paid, even though the bankruptcy court had said that she was not supposed to represent clients in bankruptcy proceedings in Maryland anymore. So that's an additional layer of violation and disingenuous conduct that is not present in these other cases. And when you layer these together, you ask yourself the simple, fundamental question I know this court has to deal with in these cases. Is this someone who should be practicing law in the District of Columbia, licensed by the District of Columbia Court of Appeals? There is nothing in the record to suggest that she has taken responsibility for these violations. There's nothing in the record to suggest that she's done anything since the violations were charged and since the hearing, or even since the board, to show that she has remedied in some sense the deficiencies in her practice that existed at the time. To our knowledge, she is not practicing law at this time, which is why perhaps no further violations.
I mean, the last 2 years, she's been suspended. She's been under a suspension, so I hope it's not law in the District of Columbia at least. But my question was compound, and you addressed half of it. But just wrapping back around to the other half of it, if you were going to point to prior decisions of ours that you would say, here's a disbarment case that looks a lot like this one, where would you point us?
Your Honor, I think that's a great question. And I can't point to a specific disbarment case that is on all 4 points like this one. I think this one is somewhat unique. I think, fortunately, it's unique. I'm glad we do not have more cases like this appearing before the court. But I think here, where in cases where you have violations that reflect some of the violations in this case, suspension has been the sanction ordered by the court. But I don't believe there's a comparable case where you have this many violations over this period of time affecting both the tribunal and individual clients, which indicate, again, a pervasive indifference to the obligation of honesty in the judicial system. It's true that in the Carisi case, you had suborning of perjury, and that's not what we have here, fortunately, but we have other conduct that clearly reflects the same concern the court had, a pervasive indifference to the obligations of honesty in the judicial system. And I note that respondent has not pointed to any factor or fact that would suggest otherwise.
The hearing committee made reference to disciplinary counsel's statement or concession that it had not proved by clear and convincing evidence a violation of Maryland Rule 5.5, essentially the unauthorized practice rule, but the hearing committee found a violation. Why didn't disciplinary counsel think it had proven that? Are you able to tell me that?
Your Honor, in all candor, I'm not. I think the record. I was not with the office at that time, but I think the record clearly shows that she was engaged in the unauthorized practice of law in Maryland at that time. She practiced from a Maryland address. She had letterhead that had the address on it, and on her letterhead it did not indicate that she was admitted only in the District of Columbia. And in fact, there's no indication that in any of her communications with her clients did she indicate that she was admitted only in the District of Columbia. We know for a fact that in her representation of Ms. Simons, she did not indicate that she was admitted only in the District of Columbia. And in fact, when Ms. Simons found out independently that she was not admitted in Maryland, that was one of the reasons she terminated that representation.
Let me ask you this last question. Do you have any thoughts about the question I asked your opponent about whether or not, in light of Harris-Lindsay, we have an entrustment situation with respect to the funds, the sales proceeds from the house where the funds belong to the bankruptcy estate? Was
Your Honor,
Ms. Mazingo vested with sufficient authority to prevent improper dispersal of the funds belonging to someone else?
Your Honor, I think the answer to that question is yes. I think certainly with respect to the $13,000, which she took as attorney's fees, she could have put those funds in a trust account until she had resolved with the trustee whether it was appropriate for her to take those funds as personal, as her attorney's fees. The record shows, and I think the bankruptcy court found that she had made some attempt to contact the trustee. They did not communicate. And rather than wait until, and in fact pursue that avenue to get the verification from the trustee that it was permissible for her to take those funds as attorney's fees, she simply went and took those funds as attorney's fees. Well, we know for a fact that the trustee did not think that was appropriate because the trustee sued her and sued the others who took funds at the sale for improperly taking money before they were authorized to do so. So yes, she should have taken other steps to ensure that those funds were kept in trust until it was determined she was entitled to take them. She did not have a right to simply appropriate those funds as her personal attorney's fees.
But as a procedural matter, I mean, I don't believe we got a 28K letter from you all calling this case to our attention. We talked about it at oral argument, but would it be appropriate for us to reach out at this juncture and sort of sua sponte make this determination if the parties haven't really had an opportunity to litigate it?
Your Honor, I'm not suggesting that you should. I was responding to Judge Thompson's question. I think on the record before you, I think the Board of Professional Responsibility has clearly laid out why disbarment is the appropriate sanction in this case, and that is the sanction that should be ordered.
Thank you, Mr. Link. Mr. Iwanoge will give you 2 minutes on rebuttal.
Yes, Judge. There's something in reference to this case and then the case that I gave in response to a question from Judge McLeese. The other case I'll draw the attention of the court is the Guberman case that the court has also referenced. It's like when you look at flagrant dishonesty, you're looking at something that you're using to try to cover something. In the Anya case, the Kanu case, and the Owenga case, either a false statement was made to a tribunal, either clients were misled, and then the court or disciplinary counsel was misled. Or in the case of Anya, blatant lies in the practice of law to courts over a protracted period. This is a lady that is dyslexic, successfully became a lawyer, practicing law. There were mistakes made, and she admitted that on the stand. But then part of the violations charged in this case included seven different violations that the hearing committee did not find. In terms of mitigation, she has no prior record, no contact with the disciplinary system. And then even the hearing committee alluded to that in its recommendation as well, that there was a fine imposed in this case of $4,500 she paid. There was an agreement with the trustee, and she was making payment on it. But then the court, the bankruptcy court that was vested with this case, never found her in contempt of court. There's no disciplinary referral, which the court had a right to do, but chose not to do it. So those things has to be put into consideration in how the actual court, in this case, the bankruptcy court in Maryland, and then the trustees that were involved looked at this case. They never referred it to the disciplinary committee in the District Court of Maryland. So based on those reasons and looking at the fact there was no evidence or a pattern of deceit, no serious devastation to her ability to practice law and her fitness has not been challenged. Nothing shows from this record that she's not fit to continue to practice law. There's been no further violations since then. No proof of serious misconduct as this court laid out in Adams and the government case. So if you look at the allegations in this case, the findings of the hearing committee, which is detailed, which no party took exception to, I ask that the disbarment be overruled and the court reimpose the sanctions of 6 months suspension or some type of suspension that doesn't involve fitness. The disbarment being the ultimate factor, Judge. Your Honor, I'll say if Mr. Wenger can take clients' funds or misappropriate client funds, do everything that he did, how could he end up with a disbarment and then somebody who's made mitigated circumstances in terms of making payments, acknowledging our own wrongdoing, not be given the benefit of doubt? So based on those.
Thank you, Mr. Owanogie. The
Yes.
case is submitted. We appreciate the arguments by both counsel, and you may now exit our courtroom. Thank you.
Thank you.
Thank you, Your
Thank
Honor.
you, Your Honor.
This honorable court is now adjourned.